Yes.
Serial number 46, ma'am.
Out of the list?
Serial number 37.
Hello, there's a
Posting memo, madam.
hello. There's
Yes.
a submission. There's a 2023 matter, my lord, from the Senior
Yes.
Citizens Welfare. The matter may be posted, my lord, because they're based on a
He's
fraud.
mentioning, let him in order. Yes.
Your Lordship, this is a 2023 matter. The petitioner has respondent number 2 wants to issue a fresh tender. And from 2023, the matter has not been posted. We filed a IF for vacating in 25, Your Honor.
Yes.
Highly posted.
My lord, the matter is a 2023 matter under the Welfare of Senior Citizens Act. The petitioner or the respondent before the original Assistant Commissioner Proceedings is not even a senior citizen. And they've cancelled the CLD and execution proceedings have been continued. I'm at threat for dispossession. If your lordship may have it tomorrow.
23 matter now. You're in the sector.
No stay was granted, my lord.
What are you doing?
They've started execution
We'll see someday. Yes.
2023 surface proceedings.
Take that.
2023 matter.
2024 succession matter.
Take it.
Lord, there's one more matter.
2023 matter, my lord. Entire amount is paid. After payment of, I wanted the documents back. At that time, they issued 13-2 notice of fixing a fancy figure. Entire amount is paid. After payment of full figure, I wanted the documents back.
Anyhow, you want the matter to be listed? Yes.
23.
The insurer in respondent, my lordship. MFA matter, the MVC to MFA, insurer in all the respondent, my lordship. So the old matter, my lordship, 2015 matter.
23 is not old in MFA.
2015 matter, my lordship.
Take it. Insurance companies appeal.
Is insurer in the respondent?
Why is he moving? So, what is your urgency for enhancement? No, that's claimant's appeal. What is your urgency? For enhancement, they give it him. Give it back.
My lord,
Yes.
surface matter. My lord, it's been a year. My lord, interim order has been granted.
Just take that.
My lord,
My
the
lord, it is
date
a
may be given. My lord.
2017 matter, my lord,
Unregistered-
kindly post it for final
Unregistered
hearing.
lessee is
You already
challenging.
mentioned, yes.
That's 2 cases. are there.
Madam,
Yes.
the respondent has deposited in need of money, my lord. It is a 2017 matter, my lord, kindly post for final hearing.
What is that matter?
It is a MFA matter, my lord. Injury case.
Take up, we'll take up. I'm taking up matters, the insurance companies appeals first, claimants appeals later. We'll see. Yes, call the list.
My lord, it is a 2017 matter, my lord. 2017 matter, my lord, 9 years old matter.
2014, 15 matters are also pending.
Sir, the insurance company already.
Yes, yes, I said no.
Yes, my lord.
Page-wise adjournment,
Yes,
list number 1, page number 5, cell number 18 to 23.
Lords, kindly not page number 1, not serial number 7. I'm withdrawing the petition, Lord. It has
take
become
that.
fractious. They have settled the matter not among themselves. He has made the payment. The document is also there.
A memo is filed stating that the loan account is settled and nothing is advised for consideration this petition. Accordingly dismissed as infractious.
Please, read.
Yes,
Page number 6, cell number 24 to 29, page number 7, 30 to
Lords, serial number 26 and 26.1, my lord.
serial number.
26 and 26.1, my lords. Kindly have it for Wednesday, my lords. Kindly have it for Wednesday, my lords.
Why?
We have engaged the senior counsel, my lords. Since
No,
we-
expedite these kind of submissions won't
My
work.
lords, kindly, my lords,
Is it coming up today for the first time? No, I'll not adjourn. Yes, next.
Serial number 32, my lord.
Serial number?
32, please.
Yes.
It has been wrongly classified as GM-DRT. Bank is not a party. It's a GM rest matter.
Doesn't matter. That also is.
Fresh
Both
matter.
The register is, yes.
Fresh matter.
This is matter before the court. It is submitted that the bank is not a party. but the matter is listed under the category GMDR. This is matter to the court having referred.
Could it be tomorrow? For some urgent. Obliged.
Yes,
My lord, serial number 27.
yes,
Lord, I intend to withdraw the petition, my lord. Let me be recorded so and disposed of. My colleague will hand over a memo to that effect.
yes. Where is your colleague?
Lord,
27, Gaurav.
I'll call, by the way, at that time let your colleague come.
please,
That
please,
time I'll, yes.
please.
Page
Next.
number 8, cell number 35, 35, page number 9, cell number 36 to 38.
Serial number 37, my lords. I appear for respondent number 1, my lords.
I appear for petitioners in this matter, my lords. Matter
Let's-
is 2013.
Where is it?
They have produced, they have filed one memo, my lords, on day for yesterday. We need to take instruction, along with the documents, my lords. We need to take instructions on that, my lords. And senior counsel SR
This is
Anuradha madam
matter-
is.
This honorable court has.
After
granted interim
vacation.
order despite that
When you
being
file,
interim
when
order.
you file new documents in the year 2026, in a matter of 2013, they require time. This is matter after
Yes, we
vacation.
have placed some
Tell
few
them
documents.
Look at
and
it, if there is
photographs,
any
my lords.
interim order, extend this next.
Page
Kindly have it
number
on 15th, my lords. Kindly have it on 15th. Just
Let's,
have
we
placed
require a
few-
week's
few
time. my
photographs
lords.
to say the situation, my lords.
List on 24th
Yes.
April. Yes,
Serial number 40, my lord. Senior,
Page number 10, cell number 39 to 41.
serial number 40. Senior was out of station, my lord. So,
40.
have you informed the other side?
yeah,
Hmm?
Devraj, yeah, I informed.
It is submitted with the land council seeks time and submits that. They have informed the same to the other side and they have no objection. This is matter after vacation. Look at it. If the interim order is there, extend.
My lord,
Yes,
serial
next.
number 41.1, my lord.
I appear for the petition in 41.1. Against senior counsel, note, we have to make
Well-
some submissions.
My lord, I appear for the respondent number 13. The panel advocate for the official liquidator is unable to be present in court on account of an emergency.
I
travel
appear for
incident to undergo.
respondents 5 to 18 in the connected matter.
It may be taken up anytime
Well-
after a week, my lord.
My lord,
After?
my lord, I'm for the
After.
petitioner.
My lord, anytime after a week, my lord.
After?
After a week.
Yes,
My
Mr.
lord,
Senior Counsel.
At the
My lord,
convenience.
I'm for the petitioner. My lord, I've traveled for this matter. Your lordships, I have no problem with the need time, my lord. I have just 1 or 2 submissions to make. The matter may be called, my lord. I'll just make those submissions, then your lordships could accommodate them, my lord, on any date. I leave it to my lord.
Yes.
Page number
To be
11.
here.
Yes.
Yes.
Page number 11, 42 to 45. Page number 12, 46 to 50.
Serial number 46, my lord.
Yes.
46, my lord. I appear for the petitioner, my lord.
And for the
Arguing,
respondent.
arguing counsel is unwell, my lord. I have informed the other side.
Same, inform to the other side, counsel for the petition seeks list after vacation. If interim order is there, extend.
47. I'm a petitioner in this case. My wife
No,
has
What
got-
you mentioned is 47,
46, my lord. I appear for 46.
46.
Please.
47.
Uh.
On medical ground, I want to take adjournment now.
Huh?
My wife has got a left hand fracture. So I want it after 2 weeks or after vacation.
This is matter after vacation. It is submitted as personal information to the petitioner. Interim order, if any, extend. Yes.
Page number 13, cell number 51 to 55. Page number 14, cell number 56 to 58. MFA final hearing matters.
Yes.
57, 58.
Yes.
Corporate matters, cell number 15, page number 15, 59, 16. Next order 6.
Milord's serial number 24, I'm appearing as party in person. So it could be called today because I have traveled all the way from
It will
Mumbai.
be called. Who said it's not going?
List number,
Yes.
list number 2, page number 1, cell number 2, please.
My lord, serial number 2, permit to withdraw the petition.
Take that.
Charges are framed, my lord, evidence in postpone. Liberty to give.
What liberty?
Charge sheet is filed, ma'am.
No liberty is required. You can proceed. MMO is filed seeking to withdraw the petition, stating that the charges are already framed accordingly. Petition is dismissed as withdrawn, giving liberty to the petitioner.
2.1.
Proceed with the pending
2.1.
litigation.
2.1 is there.
What about 2.1? Same?
2.1.
Now raising out of same, my lord, both
Huh?
crime number, but the advocates are different. Petitions advocates are different.
Let's go. 2.1 we'll call. Only two.
Cell number 2,
Problem.
page number 2, cell number 4.
Serial number 4, my lords, withdrawing the petition, my lords, become infractious, my lords, of the endorsement issued by the police itself.
Endorsement is issued in this matter, my lord, on 5/4/2022.
The matter is.
It is submitted that the police have given an endorsement dated 5/4/2022 stating that the dispute is civil in nature.
After recording the statement of petitioner.
After recording the statement of the petitioner, hence the petitioner wants to withdraw the petition. Accordingly, the memo is taken on record and dismissed as withdrawn. Yes, next.
List number 1. In Beta, cell number 1. Ali Shantappa, a petitioner.
Password mother, password.
Why?
Some urgency in that one. At a inconvenient morning session, Madhan 2:30 I will make up.
No, it can't go on like that. Whatever it is you argue.
That your lordship may kindly see my prayer is in the writ petition, Madhan.
First of all, you have to submit
Please,
that the permission is given to you or not. According to them, it
Please,
is
Madam.
given and he has placed it.
Please, Madhan. My prayer, your lordship may kindly see. B is my prayer, Madhan, to direct the
About
third
the prayer,
respondent to.
forget about the prayer. Is it correct or not? Yesterday, your submission was mainly on that they have not given the permission.
Please,
Whether they given the permission or not.
So your lordship may kindly see that, Madhan, yesterday they have filed the memo along with fishing that work order, Madhan. So far as that, Madhan, it was issued on 27/3/2023, Madhan. The work order has been issued on 27/3/2003, Madhan. That the tender, fishing tender was started on 1/7/2022. Your lordship may kindly see. Annexure A. Annexure A, your lordship may kindly see. Page 13, Madhan. May I read, Madhan, in Kannada?
You want the notice dated 3/3/2023 to be
That is,
quashed.
that is,
Why it should be quashed?
that what had happened, Madhan, subsequently that 1/7/2022 is my tender, that period was started, Madhan, for a period of 5 years, Madhan. Without issuing the work order, Madhan, that second year that demand notice has been issued to deposit the amount, Madhan, for renewal of the tender license, Madhan.
Have you exercised the fishing right of the first year or not?
No, Madhan. Because there is no work order.
Let us read your petition. What did you say?
Please, Madhan. That para 3, Madhan. It's in spite of petitioner has fulfilled the terms and conditions of the tender of the third respondent, that deposited the entire bid amount, but third respondent has not issued work order, and several times the petitioner approached the third respondent office and requested to issue work order. But third respondent has one or the other reasons postponing the matter and not issue work order. So due to non-issuing the work order, the petitioner could not able to carry out the fisheries work. The petitioner sustained huge loss. And in the meantime, third respondent issued notice to 3/3/2023 for renewal of fisheries right and directed to deposit the amount 13,15,767, Madam. And now they have produced the copy of the work order, Madam. 27/3 they have issued, Madam.
So is there any connection between para number 4 and para number 5? Para number 4, you say you could not exercise the fishing rights because they have not given the work order. Come to para 5.
Due to heavy rainfall, what had happened? Due to heavy rainfall, all the fish have come out from the tank. The petitioner sustained huge loss due to non-issue of work order.
Have you sustained the loss because the fish have come from because of the heavy rain, they have come out of the tank, or they have not given the work order?
Because we have to small pieces are in the that one side, that thereafter it is in the tank, that first we have to.
Where is that memo yesterday they have passed on?
Yesterday.
Take it from me.
27/3.
Writ petition filed on 12/4/2023, my lord. The work order issued on 27/3/2023.
27/3/2023 they have issued work order,
That is for which year?
That
Let him supply.
I'm sorry, sir.
The writ petition filed on, my lord, 12/4/2023, my lord.
12?
4/2023. The work order is issued, my lord, before this filing writ petition, my lord, this was
That is
suppressed.
not disclosed in
That
the,
was not disclosed, my lord. The work order dated, my lord, 27/3/2023. Interim order is obtained on the ground that the work order is not issued.
no, this is for which year? Look at what is the reference?
My lord, the reference, my lord, government order dated, my lord, 21/2/2014. And thereafter, my lord, the tender, my lord, that is, my lord, the tender.
When was the tender called for?
Tender was called for, my lord.
Tender was called for on 6/9/2020, ಇದು 23/8/2022 month.
23/8/2022.
22 month.
1 minute, 23/8,
22 month.
and work order is given on 27/3/2023.
my lord.
And where have you lost?
27/3/2023 work order has been issued, my lord. And annexity, your lordship may kindly see, prior to that, my lord, on 3/3/2023, demand notice has been issued for the period of 23 and 24, my lord. The work order issued on 22/23, prior to that, my lord, annexity demand notice has been issued for the period of 23/24, my lord. Annexity, your lordship may kindly see.
Just with your submissions, please come. And please give the other particulars in this letter, 27/3/2023.
Yes, my lord. Lord, the notification was invited, my lord, on 23/8/20. It is in synopsis, my lord. It is in order, my lord. It is in synopsis, my lord, in the writ petition.
Let's see.
Synopsis in, I mentioned, my lord.
Events is mentioned, my lord. On 23/8/2022, my lord.
6/9/2022 is the auction.
Yes, ma'am.
He has participated in the auction, my lord. And
I can read.
please, my lord. 19/9/22, my lord, he make deposit, my lord. Bid amount, my lord. 10,46,000.
Wait, please wait. What was the amount he is supposed to pay as per the tender?
13,15,767.
How much?
13,15,767.
No, not about this. He has already paid.
Yes, ma'am.
The earnest money
This is
is
for the
paid up-
academic year 23/24, my lord.
What is that?
For 23/24, 13,15,767. It is mentioned in the notice.
The tender itself has started.
Yes, my lord.
When you have given a work
Yes, my lord.
order in the year
That, my lord.
2023,
Yes.
and he has already deposited an amount of rupees
Yes, my lord.
10,46,804.
Yes, my lord.
That's why I've asked you to look at this. What did they say? They mention about this 10,43,000, what he deposited also in this.
Yes, my lord. Kindly pass out the matter. I will give the details.
You can read it, no passover, read it.
Yes, ma'am.
Read it, you can read it loud and tell the court what it is. This one. In that, everything is mentioned.
Yes,
That may I make submission, my lord?
Let him read.
That initially I deposit, my lord, after
Let him,
I am the highest bidder, my lord, 10,46,804 I have deposit, my lord. And thereafter they have duty to issue work order, my lord. But they have not issued work order.
I'll let him.
Yes, my lord. My lord, 14 persons were participated in the bid, my lord. Out of that, my lord, 2,10,000 was deposited as EMD, my lord. Thereafter, my lord, the balance amount of rupees 10,43,111 has to be deposited, my lord. Same has been deposited, my lord, on
19/9/2020.
19/9/2022. The balance amount was deposited, my lord. Now for the academic year, my lord, 22/23, he has to supposed to deposit, my lord, he has not deposited.
You have floated the tender itself
Yes, ma'am.
on 23/8/2022.
Yes, ma'am.
6/9/2022 was the auction.
Yes, ma'am.
19/9/2020 has deposited the unearned money deposit,
Yes, ma'am.
EMD.
Yes, ma'am.
Now, what is this amount for? For which year?
Here is not mentioned, my lord, but the balance amount he has to suppose to deposit 10 lakhs 43,311, my lord. He has deposited, my lord, on 1999. That is mentioned in the order, my lord.
Yes, so that is,
Yes, my lord.
which, because that year is complete, already 22
Yes,
is
my lord.
complete.
That is completed.
For the year
That
23
is
and
for
20,
the 5 years period, my lord.
that is true.
Yes, my lord.
For each year, if
For
this
each
is
year,
the
he has to,
amount,
yes, my lord.
if this is the amount,
Yes, my lord.
for 23, 24, if it is 13 lakhs is the amount,
Yes, my lord.
he has already deposited.
Every year it has to be, it will be
Correct.
increased, my lord.
No, that year is complete, 22 is already complete.
Yes, my lord. Further, my lord, in the said order, my lord, in the second page, it is mentioned that, my lord, in for the academic year 22-23, it is mentioned, my lord, for the academic year 22-23, he has to deposit 12,53,311, my lord.
How much?
12,53,311, my lord.
22, where is 22, 23?
For
It's
every
only
year,
for
he has
4
to
months.
deposit. For every year, he has to deposit, my
No,
lord.
that is true.
Yes, ma'am.
Question of 22, 23 doesn't arise. It's only 3 months there. You've given a 19, 2022. He's the one you have declared him as highest bidder and asked him to pay.
Kindly see that order, my lord. Bottom, my lord, for every academic year, amount is mentioned, my lord, in the bottom.
Where do you get that?
In the said order, my lord. Yesterday
Every year,
I
how
got-
much it is?
Bottom, my lord. For the academic year 22-23, the tender amount is, my lord, 12,53,311. For 23-24, 13,15,766. Next, my lord, 24-25.
How can it be, Mr. Counsel? This is you have tenders are floated, when is it? September,
Yes, my lord.
August, September. You
For
have
5 years.
finalized it end of September.
Yes, my lord.
What is left? October, November, December. So for 2023 and 22, it won't be the same amount. Something wrong with this communication. Please get.
I will get that notification, my lord. In the notification, it will be everything will
Get
be
the
mentioned.
notification,
I will
get
get the
instructions,
notification, my lord.
get instructions,
Yes, my lord.
pass over.
Please, my lord.
Yes, next.
230.
Yes, next.
Rajesh Karapi and serial number 2.
I'm sorry, my lord, day before yesterday, I could not.
Yes,
able
yes,
to
yes,
present.
yes.
My lord, I am permitted to file a memo of producing the orders of
Take
the
that.
Honorable Division Bench and the Honorable Supreme Court. They went to Supreme Court, my lord. Supreme Court dismisses the appeal
SLP is
SLP
dismissed,
filed
my
by the
lord.
PDA.
So what is the writ petition? What is the prayer in the writ petition?
My lord, writ petition, my lord. Oh, my lord, your lordship may kindly annexure D at page number
Declaring the
36,
act
my
of
lord. I am the
respondent
petitioner.
demolishing the compound wall
Please, man.
without authority of law.
They
Please,
had put
madam.
up a compound wall, my
PDA
lords.
to pay compensation of 10 lakhs.
My lord, your lordship may
Protection
kind,
to the petitioner.
your lordship may kindly peruse annexure D, my lord, at page number 36, my lord. My acquisition has been upheld by the this honorable court, my lord. Petitioner acquisition for 26 gunters of land, my lord. BDA filed an appeal, writ appeal, my lord.
What is this order?
May I just what happens was there was a dispute with regard to the land acquisition of this property. It was split into two parts. First part, when Huchamma had filed a writ petition where the petitioner succeeded. Subsequently, the petitioner before the honorable court also filed one more writ petition. On the basis that in that case, they said Huchamma, there was a positive order declaring that the acquisition had lapsed. Single judge, my lords, was pleased to pass a similar order because it was pertaining to the very same survey number. When the appeal was still pending before the honorable division bench, my lords, further dispute arose, said that they put up a compound wall, they BDA had passed certain orders, my lords, to bring it back to its original state by removing the compound wall. Thereafter, the writ appeal, my lords, BDA lost the writ appeal. We preferred SLP before the honorable court also, my lords. The orders have been confirmed because in the connected matter also, the Supreme Court has taken the view that the scheme has lapsed. But this is a little subsequent event. That's what my learned friend is now bringing to my lord's notice. Now that, my lords, the acquisition
The
issue.
reliefs that are sought.
Please.
Before this
Insofar
court
as the question of, my lords, police protection and this one is concerned, my lords, now that the land acquisition issue has been attained finality, my lords, there is
So you will
nothing
not be
further.
interfering?
We'll not be able to do it. Because we can't.
What about this compensation of?
Compensation
My
or
lord,
otherwise.
one submission, my lord. My lord, your lordship may kindly peruse. My lord, the honorable learned single judge's order, my lord, on 5th August 2019, my lord, in my favor. The Uchama case, they preferred.
I understood that.
My lord, thereafter, my lord, that has been dismissed for non-prosecution, my lord. The BDA appeal has been dismissed for non-prosecution. Without knowing the, my lord, factual aspect of the matter, BDA come with minimum measures without verifying the legal records, come and demolition my, my lord, developed my property with other, your lordship may kindly peruse.
Yesterday,
I filed a
yesterday
complaint,
you
my
made a
lord.
mention that
Please.
in the light of the Supreme Court orders,
Please.
something like it is not, as if like we have to, in the
It is,
light
my
of
lord,
the jurisprudence
then
has
my
to-
lord, I will file independent suit against BDA in competent civil court, my lord, for the damages caused to the petitioner, my lord. My lord, I request, my lord, BDA should not come on the again, my lord. That observation may kindly be.
But I'll record.
Please.
In the light of the order passed in SLP, as that litigation has attained finality, BDA has nothing to do with this land and they shall not interfere.
Bow down to that.
Please, please.
The present petition is filed. Seeking the following prayer. Learned counsel appearing for the petitioner submits that the issue with regard to the land acquisition and the dispute with regard to the property has attained finality in the light of the order passed by the apex court in SLP number, what is this diary number is shown?
Its diary number was
My lord,
at that point in time, they had not given the regular
SLP
number.
Civil diary numbers 46466 of 2024 dated 11/11/2024. It is submitted that in the light of the said order, the BDA cannot interfere with the possession of the property. Land counsel appearing for the respondent BDA does not dispute the same. It is submitted by the, it is further submitted by the land counsel for the respondent BDA that the other reliefs that are seeking, that are sought by the petitioner before this court with regard to the compensation and police protection, also taking action against the BDA officers will not survive for consideration. Expert, having heard the counsels on either side, there is a material on record. The petitioner is seeking compensation for the demolition of the compound wall unauthorizedly by the BDA and also the police protection to the petitioner. So from BDA interfering with his peaceful possession. In the light of the submission made by the land counsel to the BDA that they are not interfering in the light of the litigation having attained finality, no orders needs to be passed on that. Coming to the other reliefs, the petitioner shall avail the appropriate remedy before the civil court. Accordingly, the writ petition is disposed of, directing the respondent BDA not to interfere with the petitioner's peaceful possession and enjoyment of the property. Number two, the petitioner is at liberty to avail the appropriate remedy before the civil court.
Great. Grateful.
It's accordingly disposed.
Bill number 3, B. Mohan, co-petitioner.
Yes, who appears for the Canara Bank? So and so is directed to take notice on behalf of the Canara Bank. No representation on behalf of the petitioner. Look at this file, get instructions. Give him this file. No password. This is matter tomorrow for dismissal. Give him the file. Yes, next.
Cell number 4. Cell number 4.
Petition. Filing memo, my lord. The account has been regularized, my lord. The bank is not proceeding under surface.
The petition is filing the following prayer. When the matter came before hearing, land counsel appearing for the respondent has placed a memo before this court that the account is regularized and no proceedings are pending under Surface Act. In that view of the matter, the memo is taken on record and the writ petition is dismissed as infructuous.
Obliged, my lord.
5. Kiran BS.
The respondent hearing proxy for the petitioner, my lords. I request a short accommodation. My lord, it is an issue regarding the maintainability of the writ.
No further adjournments.
A day's time may be granted, my lord. It's the facts and circumstances are different. The arguing counsel had an inconvenience today, but we have to convince your lordships on the
You
maintainability aspect.
cannot convince the court because it is a judgment of the apex court. How can you convince?
My lords,
I have dismissed so many writ petitions. This writ petition is not an exception.
my lord, one submission, my lords. Insofar as section 17 is concerned, while it does say any person aggrieved by an order under section 13(4) would have to approach the DRT. A condition
Yesterday
precedent-
also, I have passed a
Please,
similar
madam.
argument. I have passed an order that you don't have to, that is settled law. Now, I will say that you are at liberty, DRT will entertain,
No, the only submission I have therein is it has to be a secured asset.
not
An
required.
unsecured
Whatever
asset
it
would
is,
not, my
the
lord, it
thing
was a
is,
condition
please
precedent under section
understand,
7.
in the light of the law laid down by the apex court in Vishwabharati's case against for a private financial company, writ petition is not maintainable. Yes, please
Day's
come.
time may be granted. I will
The writ-
furnish
the writ
citations in
petition is
support.
filed seeking the following prayer. The respondent is the authorized officer of Mrs. Visa Cooperative Bank Limited and other, in the light of the law laid down in Vishwabharati, the writ petition against against the asset reconstruction company and the banks which are not nationalized banks is not maintainable. Accordingly, dismissed, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Any interim order is there? Any interim order in this?
Please, notes on
Huh?
22/9/2023.
There is an interim
there is
order.
an interim.
The petitioner, the coordinate bench of this court has granted interim order. Hence, the petitioner shall have the protection. The respondents shall not take coercive steps for a period of 4 weeks. The petitioner shall have the benefit of section 14 of the Surface Act.
Cell number
Yes,
6. Dr. S. Hadmukam, petitioner.
Wait for the petitioner, my lords. My lords, one short, let me be given. We have sent the notice, my lords, but it has.
It's not about notice, this also. Same, the against so-and-so cooperative bank, the protection for 4 weeks, section 14, yes. Next. 8.
Cell number 7, disposed. Cell number 8. Cell number 8, Geeta Devi MP.
Appearing for the petition, Lord, I filed an application.
What is this
modification of-
GMFC is coming for me?
Lord, it's a IF for modification of your lordship's order, my lord. Your lordships are granted overnight visitation on first and third Saturday, and second and fourth Saturday morning 4 p.m. Morning 6 p.m. to 9 p.m. my lord. But my lord, now the fifth Saturday has been missed out. When I went to get an access, my lord, they say there is no mention of fifth Saturday. I can't give you the access. Prior to your lordship's order, my lord, I was getting access on all the fifth Saturdays. Now, my lord, because this is not mentioned in the order, my lord, now they say that I can't give you the access on fifth Saturday.
It is not that way. In fact, this very petitioner moved a memo for being spoken to, my lords, though there was certain timings, 4 a.m. instead of 4 p.m. it was 4 a.m. On the same day, the same thing was mentioned and your lordship rejected, saying that this should have been argued. That is one thing. Second thing, they keep filing applications, and one more application came to be disposed and they filed a WP. When it was suggested that both matter be clubbed and it could be taken up by one court, they did not agree to that, and that writ petition has been disposed just a week back. I have the order. Now they are not going ahead.
What they're saying, that's a different application, my lord, with regards to school academic year.
No, it is the visitation. Nothing to
That's
do with
school
school
academic year
academic.
visitation, my lord, where there is a continuous holiday in that. But my lord, now
When there is single holidays, my lord, they sought for overnight visitation for those holidays. The court granted Diwali holidays.
So it is upheld.
Milords, upheld as ordered by the family court. Now earlier, Milords, your lordship has already given first and third Saturday overnight, which he is exercising, and second and fourth Saturday from morning to evening. That is also he is exercising. There has been no
When did you realize that, nothing has been mentioned in this order? This order is passed when?
Milords, 3-7, your lordship passed the order, which I have here for ready reference.
See, here it is there.
Yes,
3-7.
And
I
immediately,
realized it, that this order needs to be modified.
Milords,
So
he did.
thereafter, my lord, then when I moved a memo for being spoken to, my lord, there was a
That is
fifth Saturday.
clarified.
Please, my
That time you didn't realize this.
lord, even in the memo being spoken, I made a submission with regards to fifth Saturday, my lord, because that time, my lord, the
Okay,
fifth
then when
Saturday.
is it for being spoken to is ordered?
Milords, being spoken to was 20.
That is ordered on 21/7/2025. How did you realize it now?
My lord,
That
on the
this
same day, I made a submission with regards to fifth Saturday
Correct.
also.
You have made a submission. I have not passed an order assuming
Please,
that
my
I have not considered it. So when did you realize? You realized it after these many months?
No, my lord, after that, my lord, in this year, my lord,
When did you file this petition?
this is on February 2020.
Then
Lord, in this
We
year, my
can't
lord,
entertain
my
Mr. Counsel.
submission,
This
lord,
kind
in
of
this
successive
year, my lord,
petition.
I'm getting 4 to 5.
one order for being spoken to, for that again another order. Please come. This
Lord,
court has-
hardly in 65 days, my
No,
lord,
no,
I'm getting only
no, no.
65 days, my lord.
The
Fifth Saturday, when I'm not
I
getting,
number 1/26
at least your
is
lordship may
seeking
consider
modification
from
of
morning,
the
my lord, morning till
order
evening.
That is passed by this court on 21/7/2025. This court has passed an order. It is the submission that the fifth Saturday
Please, my lord.
is not considered by this court in the said order. This court has originally passed an order on 3rd July 2025. Then as the petitioners move the same and the way and it's listed before this court and the caption for being spoken to. And this court, as per the submissions made, has observed that the father is permitted to have the overnight custody of the child on first and third Saturdays between Saturday 4 p.m. to Sunday 6 p.m. Now, on that order, again the petition is before this court. If at all anything that has been argued or submitted is not considered, the petitioner would have come before the court immediately. He wouldn't have come to the court in the month of February when an order is passed in the month of July. Even that apart, these kind of consecutive applications for modifying the order cannot be entertained.
Lord, at
accordingly
least on fifth
dismissed.
Saturday, morning 9 to 7 p.m., my lord.
Each case we will not hear these many times. Yes, Nick.
Cell number 8. Cell number 9.
Would respond
Appear
number
for the
1,
petition.
matter, my lord.
My lord, last date of hearing, I made a submission that the petitioners are willing to settle the matter with the bank. That's why, my lord, your lordships have posted the matter today. My lord, they have made a correspondence with the bank, my lord, they have agreed. Officers of the, my lord, the bank have agreed.
If there is no scope for settlement, the orders will be
My lord,
passed.
there is a settlement, my lord. There is a correspondence between.
My lord,
my lord.
they are sent a
Only
communication.
problem is that, my lord, they are.
Let him say, because you can't say the scope.
No,
He
they
has
are
to
in
tell what
Mumbai.
is-
They are in
They-
Mumbai.
My lord, they have sent a communication, but unfortunately, it is still in the process of initial stage because there's nothing
Then we'll
concrete
If
as
you are
such
processing
in terms of figures.
If you are processing it, then we'll wait. It is
Next week.
submitted that the petition's proposal is
2
under
weeks, my lord.
is under
My lord,
consideration.
my lords may
This
kindly
is
have it
matter
please next
after
week.
vacation,
Please,
My lord,
order if any,
please.
till vacation.
my lord, my execution proceedings has been stayed by this honorable court. My lord, if the matter is getting adjourned after vacation, then perhaps the other property where I have a security, my lord, that's also mortgage property. I mean, permitted to proceed against that because they have nothing to do with that. It's only with respect to 8 apartments that this dispute involves. There's one more set of property
The stay that is granted by this court is in respect of,
that we confined only to the,
respect of,
only to these 8 apartments. Only with respect to the 8 apartments.
in respect to the 8 apartments. Apart from that, if any other security,
That I may be permitted to
the
proceed.
respondent is at liberty to proceed.
Please.
Cell
Yes,
number
next.
10. K. Shashikant Prasad.
Filing undertaking memo and bank statement, Your Honor. Undertaking memo. And bank statement, as per bank statement, the balance is 30 lakh down. They're claiming 62 lakhs, Your Honor.
All that we will not decide, Mr. Counsel.
Lord, the affidavit copy they have served on me, what the affidavit says is he's willing to deposit 30 lakhs. Lord, as early as, Lord, January 2025 only, we had informed this honorable court that the outstanding is 64 lakhs. Now it is 66 lakhs. So he can't pay how much ever he wants to pay. In fact, my lord,
An
vacation
undertaking
notice has
affidavit
been
is filed
challenged.
that the
They have
outstanding
not
is
produced
30
a
lakhs and
statement,
the
Your Honor.
petition is ready to pay. Land counsel for the respondent bank submits that the outstanding as on
Yesterday, my lord, is
As on
60,
yesterday is 66 lakhs,
66 lakh 60,000.
60,000.
I also produced the bank statement, Your Honor.
I'm not concerned with all that, 66,000. If the petitioner comes up with an affidavit with regard to the outstanding amount and when he is going to pay, then only this court will consider. The court will not go into the aspect of what is the account, whether it is right or wrong.
Lordship may have it on Tuesday, my lord.
Let's this matter
Tuesday,
on
please.
16th of April.
Please, oblige.
16, no, not on 18th, Your Honor.
Yes, 18th of,
18th.
18th is a holiday.
17th, your lordship may have it.
Next week.
Lord, 17th, your lordship may have it.
17th, I'm also not there.
Then your lordship may have it tomorrow.
21.
Tomorrow, your lordship may have it.
Lordship, kindly
Because,
count,
my lord,
21.
Your lordship may kindly similar two matters from 2024, there is an
21,
interim order.
finally, 21. We'll deal with it on
I
that.
will leave it.
Cell number 11.
Oblige.
In this matter, liberty may be granted for me to approach the DR-80, my lords. 4 weeks protection may be granted. Last occasion, my lords, on 16/12/24.
The writ petition is filed against so-and-so in the light of the law laid down in so-and-so.
Can I
The writ
request,
petition-
can I make a small request? They were on a legal advice. In spite of
The
that, they
petition
approached
is
this
not
court.
maintainable before
So
this
far as
court.
liberty is
In light
concerned,
of the law laid down. Accordingly, the petition is disposed of giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of section 14 of this office, section 14 of the Liberation Act. You have a stay?
My lords, it was
No, no,
not
there's
to
no interim
create
order.
further charge in relation to the mortgage property.
There is
my
no
lords,
interim
on
order in this writ
16/12/2024, my lords. That's the order, my lords. On 16/12/2024, the till then respondent number 2 not to create further charge in relation
The
to the
order
mortgage.
dated 16/12/2024 shall continue for a period of 4
But
weeks.
the matter was listed on 28/12. The stay was
That-
never
That
extended.
matter
was
didn't
not-
reach, my
that interim
lords.
order,
Interim order is not
that interim
extended.
order was
Plus,
not.
the matter didn't reach, therefore it was stated as list this petition after 2 weeks, my lords.
Any of 4 weeks.
Much of that.
This next.
Cell number 12.
Same section 14, that, yes.
Cell number 12. M.A.
Yes.
Rajendra.
Appearing for petition,
Muhammad
Lordship.
Ibrahim.
Lordship,
Respondent
according to the
bank.
petitioner, there is no delay in this, in filing this. What happened was, the first auction sale notice was challenged within time.
What is questioned before this court?
The order passed by DRT, Lordship.
Let's see that.
Yes.
There is no order at 25,
Just a-
41, my lord. Page
40?
41.
41 years. And on page number 44,
The
para
present
3.6.
application is filed under section challenging the action and the measures taken by the secured creditor under the security interest enforcement rules. What happened to this?
Your Lordship, on page number 44, para number 3.6.
So it's a petition to condone the delay stands dismissed.
Yes, Your Lordship.
You say that there is no delay.
Yes, Your Lordship, there is no delay. What
Then
about
why
Your
did you
Lordship?
file IA?
Because Your Lordship, there was a direction by the office of petition to file an IA for delay. What happened was, on the first auction sale notice was filed, was challenged within time.
No, you will file an IA because office is taking objection.
Yes, Your Lordship, what happened was.
And there is no delay.
Let me explain, Your Lordship. The first auction sale was challenged within time, Your Lordship. And first auction sale was challenged within time. And it was dated.
Where is your application for
22/1.
condonation? Where is your application for condonation of delay? Page number.
Page number 145, Your Lordship. 145.
IA for amendment of application. Mr. Counsel, where is the condonation delay application?
My lord, this,
Let's see that. What did he say?
the application, my lord, was filed before the DRT. This, my lord, the facts of the case are.
Page number.
My lord, page 48, my lord. para 6.
48
Initially-
is the order.
Yes, my lord, this is the order.
Both of you are not understanding what the court is asking.
Just a minute.
Page 145. But 145 is like an amendment application.
Amendment, Your Lordship. Lordship, the amendment is only only IA that is filed, that is not, that is dismissed by DRT.
Where is your
Condemn-
senior?
Condemnation of delay was
Ask
not
your
filed.
senior to come. Does this matter? On 16.
Number 13. Dev Shetty, Commissioner.
Madam, in this case, the name of MR Shailendra it was shown as appearing for bank, Malad. Because I submitted that, Malad, to an information from other advocate from the bank that Gokul was appearing. But I contacted Gokul, he said he is also not, he has left the bank, Malad. I have served on MR Shailendra, Malad. His name may be shown.
Kumar
in the-
Shashidhar, my Lordship, and you take to file wakalat.
Shashidhar, MR Shashidhar. I have served copy and acknowledgement have been filed in the.
Is the name of Mr. YP Gokul and print the name of
MR Shashidhar.
Shashidhar.
Shashidhar, advocate appearing on behalf of the respondent bank. What is this matter about?
Matter, Malad, I mean, next week.
What
Malad.
he is trying
I will
to
do it
do-
next week, Malad.
Milords, there was an OA proceedings. Recovery certificate was issued by the DRT Chennai. And the recovery officer there has issued an attachment order. That he has filed an essay before the DRT Bangalore, Milords. What the registrar here does, he says, I have no jurisdiction, he dismisses the essay.
Then what's wrong in it?
That he has appealed.
I will do it next week, Malad. I will.
Section 30 says any grievance against the order of the recovery officer should go before the DRT to which he is attached to, Milords. That is, he should go before the DRT Chennai, Milords, and not DRT Bangalore has no
Purpose of keeping
jurisdiction.
this writ petition pending.
Next week I will
Why?
do it. I'm sorry, Malad, I could not.
Interim order is granted in this.
No, there is no interim order.
Then what is the purpose? Why are
Next-
you
I mean,
here?
next week I will
Have you, execution is complete?
Milords,
Execution.
Milords, he has given attachment warrant, Milords.
No, that warrant is executed or not?
Not yet.
Why not? There is no interim order.
Milords, I was only served a copy yesterday, Milords.
Find out from the bank. This is matter on 24th, no further adjournments. By the time the learned counsel appearing to the bank should get specific instructions.
Number 14.
May I please, Lord?
Number 14.
Here for the respondent bank, my lord, in the matter. My lord, may I request for 2 weeks' time to file my objections to the main petition? I recently been served with a copy of the petition, my
When
lord.
did you file your wakalat?
My lord,
When did you file your wakalat?
my lord, they have served copy last week, my lord. It was served last week.
At the request of learned counsel.
That's the reason.
respondent lists
OA is
this
pending,
matter
my lord. That's the
After
reason.
2 weeks for filing objections.
Please.
Yes. 15.
Number 15. Till number
For the
15.
respondent bank in this matter will accept the notice. My lord, this is the fifth writ petitions. All the measures have been challenged before the court, even including the sale notice.
Learned counsel, the petitioner is not
And-
present. Learned counsel, Mr. Xavier, is submits that he has instructions to file wakalat.
Yes,
This is matter tomorrow for dismissal.
Pacho.
Till number 16.
Yes.
Petitioner, pass over.
Why it's a matter of right everyday Passover. Court
Come on,
time.
we are ready to argue, my lord. He's, senior colleague is held up in court hall.
HCGs has come up.
Milord, 4 times, Milord, what had happened, Milord, they challenged the DRT order before this honorable court. Where, Milord, they've argued and
Do that, give the order sheet.
I filed my statement of objections. Milord, kindly come to Milord. In that I produced also. Kindly see the Milord order which I sailed before this honorable court. At Milord, page number 256. Order dated 10/11/2025. That is the order, Milord, challenged before this honorable court.
How many times you have sought for time in this writ petition?
Many times.
Yes.
Anytime.
It came up on 5/3/2026. Then the matter is listed on 11/3. 11/3 again 12/3.
I am ready. Let it
Argue.
be passed over, my lords. I just finished one appellate court, my lords. I'll argue at 2:30 for sure.
12/3, 18/3.
My lords, if that is the case, my lords, they have sought 3 or 4 times for objections at least.
No. It's not.
Lords,
right.
I'll
Only one-
definitely
one
argue
day,
today.
Only one day.
It may pass.
Please.
It may pass too.
Only once they sought for.
I
time.
sought for an adjournment
That's
only
what is
for
there
filing
on-
of
Lords,
objection.
it
I
may
filed
pass
it.
over,
next
I'll
day.
argue. I'll argue for sure. Pass.
Everyday Passover is not a routine practice.
Lords, last time I had sought.
Yes, next.
adjournment.
Number 17. Notch K. Sale number 17.
Lordships had imposed a condition, my lords, that I should pay 50 lakhs within 4 weeks. Another 1.5 weeks is there. Can I request your lordships may have this matter on Wednesday? The reason is this. The petitioner is giving a check of 20 lakhs. I don't want to argue this matter if the check doesn't get, but he's given it along with the statement of account saying that there is sufficient bank. They can present the check. If it is honored, my lords, then of course I will.
I'll make only one. My lord, this undertaking, my lord, 15 crore odd is outstanding. Sale notice has held before this honorable court. In fact, sale may not permitted me to, my lord, to proceed with the sale. You have conducted the auction. You have not finalized the sale as per the order made by this honorable court. The undertaking, my lord, from
Deposit
its
an
period.
amount-
4 weeks.
An amount of rupees 50 lakhs within 4 weeks. And on the
undertaking.
next date of hearing, they'll place a schedule before this court with regard to further payment. When is this order? This order is on 18/3.
Yes.
You have time till 4 weeks.
Lords, I just wanted to say this, my lords, 2 things. The
17th, what is?
the petitioner, it appears, my lords, has met the bank officials also. They have taken the valuation of the properties and they are indicating that it's a property which will come under the purview of one-time settlement. But I'll not argue anything beyond because first I'll have to show the bona fides. So I'm handing over the check to him. If it is honored, I'll argue further, my lords. Otherwise,
It's for?
this is for 20 lakhs. Another 10 days is there, my lords, within which time I'll make good the remaining payment. And then I'll give the schedule of payment.
If my lord direct, I'll accept, my lord, but only my difficulty is sale taken place, sale certificate not issued as per the order made by this honorable court.
That is already long back, I think this happened.
Yes.
Yeah,
No,
recently,
this-
last,
after-
pursuant to last date of order.
Where is that order?
Yeah, 21 1 minute. One day before sale. On
Was-
dated, my lord.
Petition code. I would say like it. 3/2, my lords, is the date of the.
What is that order? 3?
I'm sorry, 3/2 is the date of the auction notice and the sale,
No. He says there is an interim order by this court.
yes, my lords, your
When is
lordships
that?
directed that it should not be confirmed. Your lordships have just seen that order, my lords, the very same order,
Not to finalize the sale.
not to finalize the sale.
18/3.
18/3.
The sale scheduled to be held on 23/3 may go on, but the same shall not be finalized.
Finalized.
Land
This-
counsel
this
for
the-
the-
please.
Land counsel for the respondent submits, the respondent bank submits the sale. They've conducted the sale auction on 23/3/2026, and as per the order passed for this court, they have not finalized the sale. Land senior counsel appearing for the petitioner has handed over a TD of an amount of rupees 20 lakhs to the land counsel for the bank. It is submitted that the court has granted 4 weeks' time, and he is left with another 10 days. And within 10 days, as stated before the court, they would be paying the said amount. List this matter on 21st.
My lord may directed me to,
Please.
my lord, accept the DD, my lord. One word, my lord, directed me to, my lord, accept the DD.
The
Check
counsel
or-
for the bank is directed to accept the DD.
Lords, it's a
Check
check,
and
my
check.
lords.
It's a
My lords,
check.
the account is frozen by them.
Hmm.
We are not permitted to operate, but this is a check in their own account, my lords. They can draw the check. That's the reason why I said, my lord, I stood guard and said that I'll not argue this matter if he doesn't pay the money because.
What do
What's
you
the
say?
commit?
Point 1, my lord. They are challenged 13 to notice and on 2023 they have challenged it.
they have not complied with the order.
We'll see
They
that.
only seek for regular, your lordship may dispose
No,
of
no,
that.
we'll
There's
see
nothing
that,
surprising
17
there.
point, give that
That
17.
my lord, I'll just point out
13.1.
But I see.
why
one
this writ petition got connected. In this present writ petition, they've taken a contention of my lord MSME. Whether earlier rounds of litigation when my lord petition before the honorable court, whether that contention is raised for that purpose.
Raised
my
or
lord,
not?
Not.
Is raised. That is the only contention raised as I could see in
Let us
that writ
sir.
petition.
13.1.
Yes.
17.1 minutes, I am on record. But I
No
seek
representation
permission
has
to
been-
retire from this matter, minutes. I've already handed.
Your file, the
17.1.
123 is
That's-
filed by the council.
Received and
At para
So
9,
Ajit,
my lords, in this writ petition,
to
that's the
retire
only
the
ground
case.
which I can see is raised.
Then who is appearing in
That's my
17.1?
learned friend who's appearing in
Your
17.
file, so and so, Mr. Manoj.
Please,
please.
Manoj gave submiss that he has instructions to file wakalat and the council is permitted to retire from the case. Yes, where is it?
My lord, there's no.
Para 9, my lords, in the writ petition.
After my 13.2 notice, no letter has been issued to the bank
No, no,
saying
I-
that their MSME.
Oh, that's what,
representation
what did they say? That we
has
will
just
see.
taken one small ground there, saying that I'm a MSME enterprise. That's
No, no.
No, objections
In
are
the
there.
petition, what did they
Annexure
say?
G, H
That
and
we
K.
have given a representative. They don't say so?
That's the only thing which is said as I can see, my lords, from the representation.
It says that
No,
RBI
not
again
that.
allowed.
Please come to the writ petition and what are the amendments in the writ petition with regard to this?
Para 9. Only says RBI again allowed banks and non-banking financial companies one-time restructuring of loans of up to 25 crores to micro, small, medium enterprises that were in default in 1st January 2019 without having to mark them as NPA. Lenders are being given, this is the ground that they have raised. But they have not said that we have gone to the bank.
Annexure K, page 73. We have asked for restructuring of the loan.
Restructuring is different.
And we have produced along with the memo, my lords, in this writ petition. What is the date?
MSME, they have not gone.
No, very particularly, 25th of 10th of August 2023. Lords, along with the memo in the connected matter, my lords. Idral produce agilva. It's not produced in this.
No, no. You are questioning the 13.2 notice.
Lords, 13 to after 13 to, there is a reply given on 10th of August 2023.
Where is that?
Lords, that's filed along with the memo in the connected matter.
No.
The same thing, my lord, which you said, my lord, we don't have that copy. Let the original copy may be given back.
No, not the, that's not the document. I think my learned friend is a little confused over this. This is not the document.
When you're questioning the 13.2 notice.
Yes.
You would have said that I have, as per, after the 13.2 notice is issued, I've given my reply.
My
And
lords,
they have
that
not
is there.
considered-
My lords, maybe in the manner in which it has been drafted, I would say that there, my lords, that it is not very happily worded and drafted on the relevant documents. But 10th of August 2023, I had brought it to your lordships.
Legal ground available to the party as on that day.
Lords, not even as on the date when the writ petition was filed, lords, if the writ petition, if your lordships were to see, this writ petition has been filed on 21st of August 2023. As on that date, the representation had been given on 10th of August 2023.
No, if at all you have given, you would have mentioned it.
Lords, 1723, just two dates, my lords. 1723 is the demand notice.
Yes.
10/8/23 is the reply.
Yes. When is the writ petition filed?
Lords, writ petition is filed on 21st of August 2023.
By that time, you have already given the representation.
We had already given the
And
representation.
there is no mention about that in the entire writ petition.
Lords,
And no
it's,
copy of it is filed.
That's the reason why I said, my lords, this, if that was something which was missing, my lords, may not, if they are disputing the production, if this document is to be disputed, that's a different matter. This has been given. And in response to this, I can,
File your objection to this writ
He
petition.
did not
But I-
comply, he did not, there was a conditional order. He did not comply with the order, the interim order was vacated. What he sought here was only for restructuring. It is not with regard to, the prayers are only with regard to 13.2 and restructuring of the loan.
can I just, my lords, can I just,
It has never been a prayer,
no, I'll just,
the writ petition.
they can't go back now because,
Now, do your officer deny that signature on that?
In fact, my lord, it's not, that's what we.
Why don't you file? Why don't you-
they have given a reply. Lords, it doesn't stop there. 10th of August, I just point out, 10th of August 2023 to our representation. Lords, it's along with the memo. It's just about 4 lines. I'll quickly read it. Lords.
Yes.
This is by the bank on 25th of August 2023. Reference your request for extension of time for initiation of recovery steps. Your letter dated 10th of August 2023. We acknowledge the receipt of your letter, noted the contents. We wish to inform you that the bank has sanctioned various facilities. During COVID-19 pandemic, you were supported by sanctioning so and so, and moreover, bank has also time and again supported by restructuring the accounts of 2019 with additional term loan, and subsequently during 21, second restructuring was also done as per the request undertaken. Now also to help you to overcome the present hardship, the bank has come forward to restructure your loan account. However, the restructure can be implemented once you clear the outstanding dues as on the date.
So you're acknowledging.
This is a letter which they have sent.
My lord, kindly come to my lord, annexure R13, page number 169.
In which writ petition?
In my statement of objection, which I filed before the Honorable Court in the writ petition number 6302 of 2026. There is one more representation that we have considered, that is not in respect of MSME.
MSME only. I have not said anything other than MSME in any of my representations.
I'll only request.
No, is it your contention that 10/8 on 10/8/2023, there are two representations?
No, there's only one.
No. My lord, for a moment, my lord, kindly come to page number 169 for a moment. My statement of objection.
The first file.
My statement of objection which I filed on my lord 6/3/2026.
Page number?
My lord 169, annexure R13. It is a representation given by my lord the petitioner.
1 minute.
I'm so sorry.
10th August 2023.
My lord,
this is what is filed in this writ petition also.
It is different. That my lord.
No.
I'll just make.
In his writ petition, that is in 13 to notice challenge, this is what they have filed, 10th August 2023. And the document which the senior counsel is now.
It's the same document.
All right. And this representation, my lord, we considered at my lord page number 171.
No, that's what I asked Mr. Vignesh Shetty. This 10th August 2023 here, and what is filed with the memo is not one and the same.
Not one and the same. It's
That is
different.
what I'm
It's
asking
different.
you.
No.
So if that is the case.
Memo you filed in respect of my lord, I'll just show the my
No,
lord.
if you are denying it and your officer is denying the signature, you please file your
them file it,
affidavit on
it's no
that.
difficult.
In fact, I filed a statement of my
We
lord.
can,
what-
we can order for an inquiry on
In
that.
fact, my lord, I filed a my lord statement of objections. That, in fact, other day, my lord, senior advocate Mr. Dan sir appeared before this honorable court. They said, my lord, give us the original documents. We'll also verify because they produced before this honorable court. Photocopy. 1 minute. My lord, kindly recollect the my lord argument which canvassed by senior advocate. They said that is in the premises where we have taken a physical possession of a property. They are not produced any, my lord. In fact, my lord, we searched an entire file. That representation is not there. Earlier in petition, my lord, if they would have produced, my lord, they were given. It would have been there in the file. At least in that, my lord, matter, my lord, they would have produced
This
it.
is given after the earlier writ petition.
No, the officer's signature
In show
is,
cause notice.
that officer is in service or not?
My lord, signature, my lord, some branch signature, my lord, in some other document we signed it. My lord, it is not, I'm not in dispute. My lord, this document, my lord, this in respect of this, my lord, whatever, my lord, they produced, my lord, subsequent to filing, my lord, I'll just point. When they filed a writ petition, present writ petition, they are not produced a document. We have pointed out that document is not issued in the first instance when the matter came up for hearing. That time this honorable court directed them to, my lord, produce it. Second date, when the matter came up for second time hearing, my lord, that time they produced with one seal and signature. My lord, that, my lord, I inquired from the bank. Bank said we are not received. And in fact, on that effect, I filed a statement of objections.
That is what I'm asking, what is to be done? How do you, how do you reveal what exactly has happened in this?
My lord, attending, my
File
lord,
an affidavit, if you file an
my lord,
affidavit
my
before
request
the
is-
court,
my
that
request-
it is not your officer's signature,
my lord,
and they have not, you have not received it,
my lord, my
we'll
request-
we'll initiate appropriate
my
proceedings.
request would be, have it on, what is the date, my lord, fixed? On that day, my lord, either, my lord, I'll commit, my lord.
You verify and find out.
But this 10/8,
No, this is very much relevant.
But this is not with
But
regard
please
to-
understand, it's about between the same party, same bank.
But regularization
Advocates
is
might be
what,
different.
regularization is what is sought, not MSME.
Why we want this writ petition is,
There is no question here, my lord, the prayer is for
to
regularization.
understand what the court is saying. It's not about on the merits of the matter. Now to say that what has been stated in this writ petition after, when they have questioned 13.2, and what is their stand now? For that, we require this writ petition to be pending. Yes, does this matter on 21st?
Please give us.
And whatever, come up with an
Yes, madam,
affidavit.
certainly.
Yes,
Serial number 19,
For the petitioners, my lords,
Hearing of
the,
IA.
it is for hearing on IA, my lords. The IA number 1 is for condemnation of delay of 67 days.
What is this RP?
It's a review petition, my lords, of writ petition number 22482 of 2022.
What is to be reviewed in that? Come to the order.
My lords, Annexure J,
Yes,
Annexure F, my lords.
yes.
The order of in the writ petition is silent regarding the payment of the maintenance, my lords. The petitioner has been paying 10,000 per month from April 2018 to May 2025.
Whatever is a.
My
this
lords, now they
order-
have filed for
Please
execution.
understand, this order do not contain anything. Because the no orders are passed in this. Whatever is the order of the trial court as on that day, that would prevail. We don't have to clarify it. That is law.
My lords, we have been paying 10,000 per month from April
Then we will
28.
pay.
My lords, now they have filed for execution and for arrears of
Okay,
maintenance of
When the final MC
amounting
is
to
disposed
15,000.
of, the interim order has merged with the final order. Isn't it? Now, wherever your appeal is, if you have filed a MFA before this court, with regard to the further arrangement, you will agitate here. But as far as that amount is concerned, whatever is the order of the court, that you will be paying. It requires no clarification on that. Please come, I'll clarify that. The
May, one submission, my lords, let the notice be served on
No, no,
response,
no,
my lords,
not
and next
required.
date, senior will, I'll take instructions from the senior, my lords. One date, my lords, a date may be fixed, my lords.
That you senior come.
My lords, he's
How many
not,
days we will give for each writ petition?
any short date, my lords.
Every matter can't be listed every day. This is matter finally on 21st, no further adjournments.
Bill number 19.
An apology, my lord. Yesterday I was not able to appear. I owe an apology, my lord.
My lords, I'm being led by Senior Counsel Mr. KG Raghavan. He's on his legs before the another court. Kindly pass
So
forward.
only two submissions I'll make, my lords. One, my lords, if the constitutional validity, my lords, is not being pressed before this honorable court, admittedly, my lord, I have issued a 3-2 notification. Now, whether it amounts to a deposit or otherwise, my lord, is a question, is a disputed question of fact. So they will have to go before the honorable special court.
That's what I said yesterday.
Please, but in the scheme of the act, my lord, let my learned friend have no apprehension. The honorable special court will indeed issue notice, my lords, to the concerned financial establishment, and they can file their objections, lead evidence, and my lords.
If the party knows the advocate in High Court, it should be decided in High Court itself. Not before the password.
Please,
Kindly,
my
my
lords.
Bill number 20. Satish K.
I'm seeking
Yes.
short, I'm seeking short passover. Madam.
Will not grant passwords like this. Every matter to be passed over. Is what is this expedition?
And I'm challenging the cancellation of survey license. Madam. At annexure L, my lord, page 57.
Call for the records and the respondent in respect of the impugned order dated 6/5/2022.
Records. One video, sir.
What is the order dated 6/5/2022?
6/5/2022 is, my lord, my survey
Yes,
license is cancelled by
Mr.
the.
Ichie. What is it?
My lord, he was a government surveyor. Subsequently, because of certain issues, his surveyor license was been cancelled, invoking section 46A of the Karnataka Land Revenue Act. That they have challenged before the lordships. There is an interim order operating saying that he should continue.
Password. Password. Is 21.
Bill number 21. PP Hegde.
Your lordship, respondent number 4, your lordship, in this matter. Your lordship,
This is a
before.
very serious matter, where despite the direction issued by the Honorable Court on 19 July, a poor woman.
Why this matter is listed before me?
Melody,
Is it a parted matter?
No, it's because your lordship disposed of the matter with the direction of the trial court to dispose of the recovery of arrears. The woman is seeking deserted wife is seeking the arrears of maintenance. He is a government servant. Husband is a government servant. Could not be recovered at all. More than 20 lakhs is pending due. And your lordships made very serious observations and directed the trial court to dispose of the matter within 2 months. And that order was passed in July 2024.
Which court is this?
Trial court is civil judge and JMFC. Chikmagaluru. And nothing is recovered. And my
This
lord, one
court
more
has
aspect.
Passed an order on 29 July 2024, directing the trial court to dispose of the case expeditiously as possible, but not later than 2 months from the date of receipt of the copy of the order. Then a senior counsel appearing for the petitioner submits that though this order is passed on 29 July 2024, so far, no orders are passed by the court. The registrar judicial is directed to call for a report from the civil judge and JMFC.
Second additional civil judge and JMFC, my lord.
Huh?
It is second additional civil judge and JMFC Chikmagalur.
Second additional
Civil judge and
Civil-
JMFC.
and JMFC.
Chikmagalur.
Why? In spite of an order passed by the court, why the petition is not disposed of, or neither the petition is disposed of, nor sought for extension of time. Report shall be placed before the court on Wednesday. Let's this matter on Wednesday.
Please.
Cell number 20.
Not Wednesday, let it be Thursday because holidays are there. On 22nd,
Second, may I make one,
not 22nd, 16.
16, may I make one prayer subject to what last place, my lords. Here is a case where the husband is going to retire very next month. Now his intention is to take away all retirement benefits, my lords. So nothing is paid. Arrears could not be recovered.
16th will.
Please. And now that my learned friend is appearing for respond number, the husband, he has to at least pay the arrears, my lord. It's a case.
We will not deal all that now.
Please.
Now we are only concerned with the order and implementation of it. We will not give any further directions.
Please.
Yes.
Cell number 22, P. Narayanappa.
This matter,
Petitioner.
petitioner, please.
Sri Kumar.
That's I appear for respondent corporation. I need to secure the original records. This is pertaining to a scheme where it was granted to a scheduled caste member that he should not sell the property, but he can enjoy the property for
No, he cannot sell the property for a period of 15 years.
no,
Yes.
that is a misconception.
That is the condition.
So that is only for the purpose of taking loan for 15 years, not to.
Alienation is forever, they can't alienate.
No. That is a condition. That is a condition stipulated. I'll get my original records, my lord.
File your
My lord,
objection.
in this, in other cases.
One minute, have you filed your objection?
Yes, my lord. But I will have to get the original
Or
records.
you have filed or you are yet to file the objections?
Additional objections I have to file.
Then counsel, which respondent you appear?
Second respondent.
Then counsel appearing for the second respondent wants to file the additional objections. The same should be filed within
2 weeks.
within 2 weeks. Does this matter on 27th?
Great.
Yes, next.
Number 23, Vinod Kumar M. for petitioner.
This petition was withdrawn earlier
Yes, ma'am.
and we have filed in, we have deposited 80,000 before, my lord.
I have no objection for it all.
The writ petition is disposed of. When is that order? The writ petition is disposed of on 25th
25th
April
April.
2025, permitting the, considering the memo that is filed, that the marriage is dissolved. It is there.
It is
It's there, my lord, they can.
Why you
there is
want
no
another
necessity for-
IA?
in the name of the petitioner.
Whoever has deposited will take it. Why should you file another IA? When the order is very clear.
In the mediation report also, it was a
And counsel
clause.
for the respondent submits that he has no objection. Accordingly, the memo is taken on record, petition is dismissed. Petition is at liberty, withdraw the amount. What else you want, Mr. Counsel? IA number 1 of 26 is filed for release of amount. Already there is an order passed by this court on 25th April 2025. No further orders are required to be passed. Accordingly, IA number 1 of 25 is dismissed.
24, party
My lord, in this
person,
matter,
Vijay
32 and
Mishra.
34
My lords,
has been challenged.
this is Dr. Vijay Mishra appearing as party in person in this matter. Last hearing, my lords, you had indicated about 2 Supreme Court orders, and I have prepared detailed notes on that. These orders are not at all relevant for my petition, my lord, simply because for the first time I had applied for this loan in 2018. Since then, I had been requesting for them the loan documents.
That is not what we want. This asset reconstruction company, against that the writ petition is not maintainable. We
I
will
can
not
answer
hear
for-
any of the merits of the matter.
My lord,
You have to argue on that point.
page number 3, para 3 of S. Shobha and Muhut Finance.
Not as Shobha. What is the other judgment that,
Yes.
that you read?
Phoenix ARC.
Yes.
Yes. So in this para 12, my lords, Para 12 of Annex ARC applies where SARFAESI action is challenged in the ordinary course of action in a private ARC. This is not the scenario here, my lords. This is a dispute about the very foundational documents that they should have given to me. And finally, by intervention of this court on 3rd of February 2026, they have, for the first time, they have given a Xerox copies of the documents, only to a realization that they have produced false documents.
Even after this, my view is that it is not maintainable.
Milord,
I'll
let me
pass an
complete.
order. You can,
Milord,
you can
please.
question it
Milord,
in appeal.
please. I have a very strong point here, Milords. I'm appearing as a party in person. I myself is being an advocate. I have no problem in giving them the money or giving them the whole flat, or 2 properties are there, and they have simply exploited the situation.
Please restrict your arguments to the maintainability.
Milord.
I'll pass an order. If you're agreed,
Milord,
you can question it.
I am not challenging SARFAESI measure here.
If you're not challenging surface measures, all the more reason that writ petition is not maintainable.
Milord, actually, of course, there is another order which will support my case. Let me just finish my submission, man. I'm not challenging.
I'll hear you in the
measure.
afternoon.
My lord, even otherwise, my lord, section 17
The writ
provides.
petition is not maintainable.
Yeah,
Let him,
maintainable.
whatever,
My lord,
whatever he wants to submit, let him submit. I'll hear him and I'll pass orders. Yes.
From the date of filing
Pass
of the
over.
writ petition, this is the submission which is going on.
If allowed, I can give my written submission.
Yes, give the written submissions. I'll pass the order. Yes, give the written submissions to the court officer.
Should I file it down
Give
or?
it to the court officer.
I can give it.
Yes.
So I will do it.
Learn it. The party in person wants to submits that. He has the written submissions. The same will be placed. Yes. The same is taken on record. Give it to the court officer.
I will give.
Yes.
And afternoon we are.
Nothing. You give the written submissions. Looking at it, I'll pass orders. After giving the written submissions, what is there? I will look at the written submission.
I will give the submission, but still I would require.
My lord, this cannot be, madam. This.
Please wait.
Milords, this is a fraud, the
Mr.
case of forgery. The
You
document that
understand,
they have
whatever
given.
you want to submit, you submit through written arguments. I'll consider and pass orders. Another hearing is not required. Heard the
I'm
parties.
submitting. I will
Reserve.
submit.
Yes.
Much,
Yes, next.
25.
much of it.
Lords, I appeal for the petitioners on this matter.
30 minutes. Already we
Give
have.
it to them.
Lords, I'm filing 2 memos. One matter has become infructuous, in which only the auction notice was challenged.
Oh, 1 minute.
This
No.
court has passed orders, my lord,
This-
let it sustain. Let it remain.
WP number, which writ petition? I passed a common order on the last.
My Lords, that's the one I filed a recall.
Which one?
I filed a recall in both the petitions. Your lordships will have to recall the petitions, recall both the writ petitions, and then, my lords, your lordships will my IA will have to be allowed for recall. Then your lordship will have to pass the order, because the fact that the DD has now been, the amount has been refunded also has to be recorded.
That
And,
I have already passed an order.
my lords, I filed a recall. I'm withdrawing the writs, my lords. The question of maintainability would not arise. I'm withdrawing the writs. I've come to the court. Now I'm withdrawing it. They're refunding my money. Therefore, my lords, the only order your lordships will have to pass is that the writ
I have serious
petition-
objections, my lords. On the day this petition was dismissed, as the WP is not maintainable against a private bank. After 2 days, they filed IA for recalling on the ground that she was not feeling well. Now, in the meantime, your lordship entertained that IA only for the reason that I should give them back the
The IA is
reminder.
not entity.
No, but even if you want to withdraw, the writ petition is maintainable, it's not maintainable. That I will
My lords,
observe.
my lords, on the day that your lordships were going to dispose it as not maintainable, I could have withdrawn it that day itself, my lords. I'm now doing
How
the
does
same
it make a
thing.
difference?
My lords, I want to withdraw the writs, my lords.
No, that's what I'm asking. What is the
Because
difference
it's not
between the two?
maintainable, I want to withdraw it, my lords. Your lordships have protected me by asking the bank to refund the order that was passed, asking me to deposit. This, my lords, would.
When you have filed an IA, I said, I'll hear your arguments and I'm going to reiterate the same order. That's
lords,
what
I'm
I said.
withdrawing it, my
If you
lords.
want to withdraw, that doesn't mean that I have to, this writ petition, that observation will be retained with regard to the maintainability of the writ petition. We can't let
My lords, if
further
the matter
litigation
is
like
being
this.
withdrawn, the question of expressing
First
any
of all, I'm not
view.
recalling the order.
My lords,
I'm
that
not
can't
recalling
be,
the
my
order.
lords. I was unwell that day. I have
I will
filed a
record that.
personal affidavit.
I will say you have passed this. I'm not
My lords,
interested.
all that can be done only if your lordships recall it in the first place. On 26 March,
Yes, I will say that order is it stated that you are not unwell, that day you're not, and these are the reasons. Now, in spite of that, the fact remains that the writ petition is not maintainable, and I'm
Because
going to
I'm
consider
seeking
that.
to withdraw, my lords. I can't be worse off even if I'm withdrawing the
No,
case.
you can't have everything
My
as
lords,
far
I'm
as you
withdrawing the
want.
matter, my lords. Kindly see the conduct of my learned friend. That day he got the matter,
Don't want to hear any
matter
arguments on that.
dismissed. He
Please
did
come,
not tell
please
your
come.
lordships
The
that
writ petition is
10.53 crores was deposited.
The IA number 1 of 26 is filed.
My lords, kindly permit me to withdraw the matter, my lords. I'm not.
Order dated 26/3/2026.
My lords, then your lordships may reject my withdrawal and say.
That's what I'm going
Kindly
to
take
do.
my
IA number 1 of 26 is filed to recall the order dated 26/3/2026.
My lords, kindly note the memos, my lords. I'm
Yes,
handing
I
it
will
over.
record everything. It is stated that
Madam,
this court on
madam. My lords, your lordships may take my memo. The court officer is refusing to take it. My
What is
memos
that?
may be taken.
take that. Where is that order? This court on.
I'm withdrawing it to pursue alternate remedies, my lords.
That is what I have also done.
My lords, but I'm.
No, that is also I'm saying.
Lords,
I don't know what is this logic behind this argument. You want to withdraw? You want to? I also said you withdraw, and that's what I said. I am not. I said dispose of giving liberty to the petitioner to avail the appropriate remedy. How does it vary?
My lords, because I've not had the benefit of seeing the order your lordships have passed on 26th in my absence.
Now I am passing in your. That day, without even looking at the order, you filed an IA to recall the order.
Not available, my lords, because I filed the IA for.
That's what you have to look at it. That's what is the order passed. That is what I'm saying. No, take out that order. Order dated 26/3/2026.
My lords, if your lordships are recalling it, then your lordships will have to pass a fresh order. Unless you're treating it as being spoken to, my lords, I have not filed such a memo. And the fact of refund also has to be noted.
No, 26/3. Where is the order of 26/3? That must be in the other expedition. See? The repetitions are filed against Westchester Cooperative Bank, which is a private bank, and in the light of the judgment passed by the Honorable Apex Court, so and so, again is so and so, is not according the writ petitions are disposed of.
But I've not had an opportunity to controvert all
liberty to the
those
petitioner
points.
without even awaiting for it, without anything, you file an IA and you make all these submissions. The petitioner shall, please listen to the court. The petitioner shall have the benefit of section 14 of the Limitation Act. That is what the court said. Your interest is everything protected. Now you want the court to pass all.
ARC judgment, my lords, is not applicable to a cooperative society and bank.
Please, this is, I can't appreciate
lords,
this.
therefore, withdrawing-
Please listen to that. The other day you argued, you accepted that you are not on the merits of the matter.
Please, my lords, because I wanted to withdraw it.
Then what is now, if the court gives a finding that this is what it is, but you want to have a second round of litigation on this so that the writ petition can be filed again, or what? That's the only inference the court can draw.
No, my lords, that is not my intention. There is
And
no.
this much of now you made your what you want to say, I heard. Now I'll pass an order, please.
Then, my lords, your lordships may note that the DD has
Everything
been refunded.
I'll record.
And your lordships may record that
That's
I've
already
also sought
recorded
to
and I'll
withdraw
record.
it,
Please
which
listen to
has
the
been
court.
not granted.
What is the order? This court has passed an order on 26/3/2026, wherein this court has recorded that in the right of the order passed in Phoenix ARC Private Limited versus Vishwa Bharati, Vidya Mandir and others, arising out of writ petition number 35564, 35566 of 2015, dated 27/3/2018. The writ petition is not maintainable, and accordingly the writ petition was disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT, and the petitioner shall have the benefit of section 14 of the Limitation Act. After that, an IA is filed before this court to recall the order dated so and so. stating that the council is unwell on that day. And in spite of that, the writ petition is filed and arguments were also advanced stating that the writ petition against the same is maintainable and has relied on the judgment of the, there is a judgment, see, relied on the judgment of this court in case of S.A. Hakim and H.N. Tilhari, ILR 1994, Karnataka, 2008. And it is also submitted that by virtue of the interim order passed by this court, passed by the coordinate bench of this court, an amount of 10 crore 53 lakhs is deposited. The 10 crore 53 lakhs is deposited. And this court made it clear that that amount, whatever is deposited by way of an interim order, when the writ petition is not maintainable, the same will be refunded to the petitioner. And then the petitioner continued to argue on the maintainability of the writ petition. Then this court has asked the petitioner to look at the judgment in Vishwabharati and convince this court. On that day at 1:30, a mention is made stating that on the maintainability of the writ petition, the petitioner is not arguing on the maintainability of the writ petition, and it is only on the petition is only on the aspect of return of the amount. Then, considering the said request of the petitioner, this court passed an order on 1/4/2026, which reads thus. Please extract that order. Thereafter, on the next day, the DD was brought in the name of the petitioner. For that, an objection is raised stating that in fact, the DD is given by, yesterday there is an order that's there with her. The DD is given by so-and-so, give that so-and-so. DD is given by so-and-so. Hence, the DD has to be returned on the name of so-and-so. That is there in the earlier order, yesterday's order. In the name of so-and-so. Then the land counsel for the bank submits that as per the order of this court. Then this court has directed the counsel for the bank to get the DD in the name of so-and-so. Accordingly, today he has placed a DD before the court. Land counsel submits that she has filed a petition to now the memo to withdraw the petition. Hence, this court has to recall the order dated so-and-so and should permit the petitioner to withdraw the writ petition with the liberty to avail the appropriate remedy. The order dated 26/3/2026 is with reference to is also giving liberty to the petitioner to avail the appropriate remedy. Hence, in the considered opinion of this court, the order dated 26/3/2026 need not be recalled, but the same is modified to the extent that the amount of so-and-so, 10 lakhs 50.
10 crores.
10 crores 53 lakhs.
53 lakhs.
53 lakhs is refunded to the petitioner by way of a DD in the name of so-and-so. Yes.
There'll be an order, they accepted handed over the demand after that.
The DD is handed over to the counsel for the petitioner.
Lord, I'd just like to point out that I've not made any application for modification. There's no IA on that.
I said so. The court can do it.
Please, my lords, your lordships may say all contentions are kept open.
Yes, all contentions are left open.
Please, my lords, I'm grateful.
Number 26.
My lords, I'm for the petitioner in this.
Enter K.
I'm for the petitioner, my lords. We have engaged the service of senior counsel Adavi Malleshwar Rao from Andhra, my lords. He was unable to come today. Kindly have this matter on Monday, my lords.
When has this matter come up? This came up on 7/4. On your request, it is listed today. Again, why would it be adjourned today? You can't take the court, very casually.
No, my lords, I apologize. Senior counsel is not well, my lord, so he couldn't make it up for today. Short accommodation.
The process is complete.
I beg for a short accommodation.
On 22nd, no further adjournment.
Grateful, my lords.
Should I appear for the petitioner, my lord? I may be permitted to withdraw the writ petition. A memo to that effect is being
7.
27, he wants to withdraw.
తీసుకోలేపా మేము.
MMO is filed. Seeking to withdraw the writ petition, accordingly dismissed as withdrawn. Yes, 28.
Till number 28. 28. Aya Kenna.
Yes. What is this writ petition?
My lord, he claims that he has an certificate or degree in
Come to the prayer. What is the prayer for?
prayer at page number 18, my lord. To direct the respondent to accept the application dated 6/9/2019, filing the for registration without any clarification from the fourth respondent and place the same before the second respondent. He
To
claims
direct the
that,
second respondent to accept the application dated.
yes, second
filing for
respondent is,
registration without
yes,
any certificate from the fourth respondent.
Yes.
Who is the second respondent?
second
Chief
respondent,
Executive and
Chairman Registration Committee for Karnataka Private Medical
Establishment.
Establishment. The issue is, my lord,
Fourth respondent is
is
district
the
secretary.
taluk health. Issue is, he claims that he has a private degree under alternative medicine. He want to practice as a doctor under the KPME Act. He is not a recognized practitioner under section 2K of the KPME Act. That act also is produced, my lord, kindly see page number 22.
No representation for dismissal on 21st, not on 21st, it's on 16th.
Till number 29.
Appearing for petitioner, my lordship.
29, the similar matter yesterday your lordship was disposed of, where he is seeking a caste certificate based on the R4.
Oh, similar matter.
Similar.
Where is that order? Yesterday's one. You have taken it.
But he may not get it by, there is a Supreme Court judgment, recent judgment. So he claims that he want to be a caste certificate in the name of Beda Jangama. But
Beda?
since Beda Jangama,
Hmm.
so that is subtle principle that he is not entitled. But since he is seeking a mandamus based on the R4 letter.
Let them pass
Yes,
that order. We are
to
not
that
giving any
extent. Yes,
positive
yes, please,
direction.
please, my lord.
The writ petition is filed, seeking the following prayer. It is a case of the petitioner that he belonged to Veda Jangam scheduled caste as enumerated in the provisions of the as a say so and so petitioner belongs to so and so caste and the is it classified as a scheduled caste.
Release ಆಗಿಲ್ಲ.
The petitioner has made an application dated 1/8/2018. And the concerned revenue inspector conducted an inquiry and recorded the statement of the petitioner and also drawn Mahajar at the place of the residence of the petitioner. The petitioner has furnished all the relevant documents before the fifth respondent authority so as to substantiate the fact that she belongs to documents furnished by the petitioner and also the report of the local revenue inspector has rejected the claim of the petitioner, holding that she belongs to Veera Shaiva Lingayat community and not coming within the enumerated scheduled caste list. Being agreed with the endorsement dated 2/8/2019, the petitioner approached the fourth respondent authority by filing an appeal under section 48(4)(b of the Karnataka Scheduled Caste, Scheduled Tribe and Other Backward Classes Act 1990. Petitioner has pleaded and substantiated that she belongs to Veda Jangam Scheduled Caste community. It is stated that the petitioner has produced several documents, including the school certificates and also the government orders and circulars issued by the respondent authority for issuance of scheduled caste certificate. The fourth respondent authority, after verification, passed an order on 16/9/2019, partly allowing the appeal filed by the petitioner, directing the fifth respondent authority to pass orders in accordance with law after verification of government circulars, judgments, It is stated that being agreed with the demand passed by the fourth respondent, the petitioner filed appeal before the third respondent. No, against the orders passed by the fourth respondent, he went before the third respondent. What happened to that?
My lordship, there they didn't take any steps regarding that, my lordship.
So now you are making two claims. One is you say the third respondent should consider your case as well, basing on that what is impugned before third respondent is fourth respondent order. You say the remand order as for the fourth respondent order, the third respondent should have considered. How can it be? How can you ask simultaneously? Either you have to pursue before the third respondent, or you should be happy with the fourth respondent order and pursue before the third respondent.
My lordship, what the third respondent authority has been remanded back to the Tahsildar to consider it as fresh matter, my lordship.
That is done by fourth respondent.
My lordship.
That you have questioned in before the third respondent. What happened to that? You said so. Look at paragraph number 5. And again, when it comes to paragraph number 9, you will say fifth respondent has not taken any action.
My lordship, in that.
That is, instead of third respondent, yes, fourth respondent is mentioned as a third respondent. Kindly see page number 21, annexure E.
No. He's now in the writ petition, he's questioning an order, seeking a direction to the fifth respondent.
Fifth respondent.
Fourth respondent has remanded the matter to the fifth respondent.
Yes.
Later, he has questioned the order of the fourth respondent before the third respondent, questioning the remand order. Look at it at paragraph number 5, 9 he says that, not 9, 5. It is submitted that being agreed with the order of remand passed by the fourth respondent, the petitioner filed appeal before the third respondent.
That is not forthcoming in the entire petition. If it is, if you have challenged it, then.
And there is no challenge to that. And when you have preferred an appeal to the third respondent, why should there be a direction to dispose of to the fifth respondent? Please look at what is that you are seeking. Yes, next. This is matter after vacation. Yes, 38, 30.
20.
20?
Cell
Yes.
number 30. Purnachandra B. Pattar for petitioner.
Senior counsel is in another court, so kindly grant a short pass over.
Yes, pass over.
Cell number 31. V. Mohan.
Appeal for the petitioner, Milan. Petitioner is a MSME unit, Milan. Importing dry fruits and nuts. More than 50 employees are involved.
What is questioned before this court?
Milad, this is Article 14 of this thing, because partiality has given. They are not sanctioned restructuring the loan. I requested for a restructuring the loan. After issuance of 13-2, immediately I give my representation, Milad.
No, is it a matter of right restructuring the loan? What is Article 14? They will do it as per their plan.
No, Milad, they are partiality. I have given my representation. They are simply rejected. As per the MSME Act, they have to form the committee. They have to form the committee.
You have to urge. Yes. That is what you have to urge,
Yes,
not
ma'am.
Article 14.
Yes.
Now, what is that? What is the prayer? Come to the prayer. Quash the first respondent's bank letter dated.
They are rejecting my
How
restructuring
is it
letter, Milad.
violative? Please come to the circulars and tell the court how it is violative of so and so.
Yes, Milad, they are issued the 13-2 notice in page number 28.
Date?
2012-2025.
Where is your reply?
A representation 12-1-2026. Within 15 days, I gave my representation.
2012-2025 to 12-1-2026 is only 15 days.
Yes, my lord, that's around 20 days, 25 days.
When you are supposed to give? Reply has to be, what is the time limit for the reply under 13.2?
13.2, man, they are asked for restructuring my loan, my lord. It is nothing but restructuring loan.
You have given a reply. for
MSME
that.
Act, it's very clear. It is a government of
We'll
India,
go to the MSME Act.
Union of India has given several
That the
schemes
court
are
is-
given.
the court
my lord.
is aware of
But
it.
respondents, the department, they are not following. Even RBI is not following.
No.
I made RBI and
What
Union
all
of.
the advocates have to understand is, as long as you don't answer to the court's query, I will not even move one inch.
Yes,
I've asked you, 13.2 notice is issued.
yes, ma'am.
For that, you have given a reply.
Yes.
And what is the time limit for giving a reply under 13.2 is the simple question I asked.
Milad, sir.
You answer to
Yes,
that.
Milad,
What
it
is
is,
the- what is the
the
time
reply
limit,
was
sir?
given by the petitioner. He's a common man. He is not a legal professional or something. He is aware of all the legal process. He as a layman, immediately he has
And
given
that
a
is
letter.
not open to the advocate to submit that, isn't it?
Yes,
Whether
it
non-
is not a legal notice or anything.
Not
It is
required. I
purely,
just asked you, you didn't even answer till now. What is the time limit for a 13.2 notice?
so within week's time, Milad, we have to give a letter.
What is it, Mr. Vinayak, for me? What is it?
13.
15 days or what is it?
15 days.
15 days. When was the notice received by you? Where did you say so?
My lord, here, my lord, he comes with, he says he's a MSME, he has produced. Only issue here, my lord, is he has two firms, partnership firms. Both the partnership firms, the same partners. And in both the scheduled properties are mortgaged to the bank. One is Manjunath Traders, and then this second one is Rishi International. This Manjunath Traders, the outstanding is around 11 crores. In this Rishi, the outstanding is around 16 crores 33 lakhs.
Both are MSMEs.
He has not taken the stand in that
No,
Manjunath
account
Traders.
is an MSME account.
With regard
Yes,
to,
my lord, I have given
Let
my.
him say.
he has not taken that stand of him.
Not stand. MSME account or not?
It is not, if I'm right, that account is not an MSME.
Which account is MSME account?
This Rishi International, my lord.
Huh?
Rishi International.
So when an account is an MSME account, when I can understand when it is not in it is not an MSME account on the face of it, 13.2 giving a reply telling all that will arise. Once the bank knows it is an MSME account, and what should follow is, you should follow the circular
So
issued by
before that, what has happened, my lord? Same properties, all the properties.
Before declaring any asset as NPA or thereafter, there is a separate procedure for the MSMEs
Yes, my lord.
that you need to follow.
But what has happened here, my lord, if your lordship may kindly see, this Manjunath Traders became NPA first, in which the same partners are there, same properties are there. And 13.4 notice were issued. There they challenge the 13.4 notice before DRT. They don't take the stand of MSME there. They contest that matter, they go to the DRT after 45 days have expired. It is posted for orders. Now the same property subsequently in this matter, when we issue notice, they come out and take the stand. We tell them that we can't now, since 13.2 notice subsequently you're issuing this reply, we can't consider, because the same properties which are mortgaged between the same partners, we have already proceeded to issue possession notice. So the remedy is not there.
MSME and which is not an MSME, for both they have mortgaged the same property.
Yes, my lord.
Mortgage is one and the same.
Yes, same partners are the same, mortgage is the
Now,
same.
for example, this MSME, something will happen. What will happen to the other case?
My lord, because he should have first in Manjunath's account, I think that's also an MSME account. I can produce the documents with regard to that case. There he should have raised.
That also MSME account, Milad.
If he says it's MSME, he has not raised that. He allows that to pass.
No, that I'm not able to understand from the bank's perspective. You know that it is an MSME account, and why should somebody tell you that it is an MSME account?
My lord, the judgment as well as what mandates is, my lord, that
That is somewhat
verifying
Why
documents.
should when you know that it is an MSME, why should somebody tell you that?
No, my lord, what happened?
Isn't it unnecessary
No,
litigation?
my lord, what it is clearly law says is that we should have verifiable information that they are falling into. They're falling into.
No,
this one.
you can ask them about the verifiable information. Admittedly, it is an MSME account. Then you ask them that now we are going to do so and so. Please place before whatever document you want, you can ask for it.
13.2 notice, that's the remedy that they have got to come and tell us, my lord. After 13.2 notice, they have the remedy to come and tell us, look, we are an MSME, give us the benefit. My lord, we are bound to constitute a
Actually,
committee.
banks can't be, like any other common litigant. They can't. You are there to, you say that Reserve Bank circulars are binding on always, which is convenient to you or which is not convenient to you.
My lord, the other thing is, my lord, even there is a RBI guideline 2000 which says only one time the account can be restructured. Again, then the MSME benefit, they
So
cannot.
is
seek
it your
for.
case that this is, how many times you are
Here they have
restructuring it?
taken some.
No
COVID
restructure, my lord.
They have taken some COVID loan. That also, there's a restructuring of the loan. That's in wondrous. But what I would like to say is, my lord, in this case, since the first loan account which was issued NPA and 13-4 notice was issued, since they have not come before the court and raised the MSME ground after 13-2 notice, now they putting the clock in respect of both the loan accounts, which he has, and there I have put the property to sale, which is subject matter of this writ petition. Sale notice has been issued. He has gone and challenged it day before yesterday before DRT. My lord, and sale confirmation is stalled. Now, at this juncture, can we put the clock back and say that the representation has been given in the second matter, and hence everything has to go back? That's the only issue, my lord.
Because the properties are one and the same, he can't have no, as far as the matter that's pending for the DRT is concerned, they can proceed with the matter. You have not taken that ground. And the properties which are mortgaged are both one and the same. You
Yes,
can't
ma'am.
stop it.
No, this is totally a MSME sector. Both the loan accounts are MSME.
When did you tell them that you require the?
Even the DRT also, we have taken the same ground. It is a MSME sector. It is pending before.
I'll produce the material.
For other
I
account.
can produce
Come
all.
up with all your objections.
I'll produce all.
I'll know, this is matter. On
Let there
26.
be a status quo, my lord.
This is matter on 26. By the time the learn council for the, Mr. So-and-so takes notice, your name is there. So, yes,
The second respondent, third
the
respondent.
bank shall file the objections.
RBI and Union of India.
Who appears with the, file your objection. The Reserve Bank of India shall file their objection.
25th, not
24th. Yes, 32.
Cell number 32, this again 2033. 33, KN Mahabaleshwar Rao.
Case. The petitioner, kindly see annexure A. The first respondent, the owner of certain apartments, and in respect of apartment G01, he has created a simple mortgage for 40 lakhs.
Indian Overseas Bank, who appears?
Indian Overseas, I will
You
find
appear?
out.
Huh?
Keshav Bhatt.
Yes, Mr. Keshav Bhatt is directed to take notice on behalf of fourth respondent bank. Then counsel for the petition shall serve the copy of the writ petition on the council. This is matter tomorrow. Tomorrow or on Wednesday? On
Wednesday, 15th.
15th.
Cell
Yes,
number
34.
34, admission by
Admit
MFS.
post of final hearing, call for the DCR.
Cell number
34.
35,
But notice to others.
35.
35.
There are other three parties there in the 33. Notice to other respondents.
No, first of all, let's hear from him what it is, then we will order notice. Yes,
34 I appear.
34. What is that?
35, ma'am, sorry.
30.
35.
Why 34 is, it is not on the memo? Yes, admit final hearing. 35?
35.
In 35, ma'am, this honorable court was pleased to permit the claimants to withdraw the amount deposited by the appellant in all the appeals. Ma'am. Due to technical reason that the respond number 3 in 3806 of 2017, that is 35.3 and 35. Respond number 3 is died, madam. Respond number 1 and 2 are the legal representative of the respond number 3. Therefore, on technical that point, madam, the claimants are not able to withdraw the amount.
Whether the LR petition is ordered before this court?
No, madam.
You have to bring the LRs on record.
LR is already on record, madam. Respond number 1 and 2 are
Third
the.
respondent, no represented by the other, that you have to file an application.
I have filed, madam. Now they have not filed, madam. Therefore, I am the urgency is for me, madam. Therefore, I am the claimants, madam. I am the claimants. Well, the respond number 3 is the mother of the deceased. Respond number 1 and.
How can you file LR petition? The information is given by them.
Memo is filed, madam.
By them?
And I have filed memo.
Yes.
Kindly on 11.
Inform him.
Mukkanappa.
Inform the council, pass over.
Much obliged.
Yes, please.
Cell number 36.
Here for petition.
My lord, I filed the detailed objection statement, my lord. I'm giving a synopsis containing the dates and events, my lord.
Do that. Why is that? What is this? Just,
My lord, this is a case where, my lord, on the earlier round of litigation, page 90, my lord, a writ petition was filed, my lord, challenging the communication issued by the respondent bank. This honorable court, my lord, passed an order. My lord, page number 94, para 4 and 5 of the order.
Page number 90.
94. My lord.
Oh, with regard to that interest or
Commercial rate of interest.
Also, in para 5,
On
this
perusal of
court
the-
held that, my lord, they can charge only from 20/9/2025. Para 5,
para 5
para 5, 20/9/2025. Even for that, they have to
will be entitled
follow
to
the
charge
procedure as
commercial rate
stated
of
above in
interest
para 4.
from 22/9/2025, but it has to charge rate of interest at the rate for any period of time from, it must be only after ascertaining all the material data.
That is, it says again from 20/9/2025.
No.
At that rate for any period of time from 20/9.
Or till such time, commercial rate. After
No.
that, they should give you an opportunity.
No, my lord, your lordship may kindly, the submission made by the counsel for the
No,
respondent bank.
let's read 5 as it is.
Please,
5.
before that, what was the submission made by counsel for respondent number 3, para 3, page 94. Last 5 lines, my lord. Para 3, last 5 lines of para 3. The learned counsel also submits that this court must dispose of the petition observing that the second respondent is entitled to commercial rate of interest, not just from 22/9/2025, but also from the date of sanction 29/7/2017. And the court holds the bank is entitled to charge a commercial rate of interest from 22/9/2025.
No, that's not true.
No, what is the operative portion of the order?
Operative portion, my lord, may I read, my lord, para 4 and 5, my lord? This court on perusal of the records, more specifically the declaration as aforesaid, is of the view that the petitioner cannot take any exception with the second respondent calling upon him to pay interest at the commercial rate of interest if he has utilized the loan extended for construction of a residential building to a commercial construction. However, the second respondent cannot, relying upon the impugned communication, assert that the petitioner will be liable to pay interest at the commercial rate of interest from the date of sanction or disbursement, because firstly, the communication does not state that. Secondly, the date of construction, the date of assessment for commercial purposes, and the other details will have to be examined before there could be any demand. As such, the petition stand disposed of, observing that the second respondent will be entitled to charge commercial rate of interest from 22/9/2025, but if it has to charge rate of interest at that rate for any period of time from 22/9/2025, it must be only after ascertaining all the material data such as the above.
Yes.
It is,
Yes. Then,
therefore, my lord, after this, my lord, the copy of the order along with the letter was submitted to the bank. My lord, thereafter bank now has issued communication at annexure A, holding that, my lord, the honorable court has not quashed the communication dated 22/9/2025. Therefore, you are required to pay
come to that.
annexure A, my lord.
Page number.
Page 22, my lord. Lord, para 2. With reference to the above, married. With reference to the above, we would like to bring to your kind notice that we are in receipt of the certified copy of the order from the Honorable Court dated 27/1/2026, received to us on 7/2/2020. On perusal of the order, it has been observed that the Honorable High Court has clearly denied your prayer for quashing of the communication dated 22/9/20.
I've seen. What are your?
My lord,
Consequently, and the annexure B came to be issued and annexure C.
Yes, yes.
And
Now-
thereafter, my lord,
Now I recollected the fact, yes.
my lord, then in the meanwhile, that account has become NPA. And bank issued the notice under 13.2 that he has not replied. Here we have mentioned now, my lord, that only one question is whether the property constructed by taking the loan for residential purposes, whether it has been used for a non-residential purpose. Number one, if so, whether the bank has the right to recover the money. For this, my lord, I have produced, now my lord.
No, we will not consider all that. He is before this court questioning the.
13.2 notice only.
Annexure A. You say that the court has not quashed. That is not what the
No,
court
that
said.
is not, my lord. Now the next stage has come. Now this
Next
has
stage, we will not go. We are only concerned with A, whatever is the impugned correspondence.
But 13.2 notice only, this has been challenged
That is,
here.
if it is whatever steps you have to take, you will take.
No, it had taken now, that they are challenging 13.2 notice.
13.2 also it is.
That is what I am
challenged.
telling now, my lord.
Consequently.
13.2
Consequent
notice
to
has been
this.
issued.
Come to the communication.
Yes, my lord, communication annexure A, page
Hence,
20.
No, not quashed, and the communication dated issued by us to refer the amount pursuant to the so and so. Now, you have to, unless and until this exercise you redo, whether you have to charge him on a commercial interest or on a the other non-commercial one, how can you declare it as?
No, my lord, this what the honorable court said, entire thing has been done. That is what I have mentioned in my objection statement. All this exercise has been done. My lord, number one, that engineer has instructed the building.
When
and
is the
found-
order of the, when is the order of the court?
My lord?
When is the order of the court? 96.
Yes, my
that
lord.
Order is when?
19.6.
Yes.
Before, my lord, in the objection only.
Please wait.
Yes, my lord.
This order is on 27th January.
Yes, my lord.
When did you reply?
My lord, reply was submitted on, my lord, 7/2/2026.
When is the impugned communication?
Immune communication is dated 12/2/2026.
In 12/2/2026 communication, where did you say that you have done all the exercise? Please read that. In terms of the order passed by the High Court, we request you to pay the interest amount.
Yes, ma'am.
High Court has not passed any order in favor of you. High Court has passed an order in his favor.
My lord, High Court has passed order in both the favor because this honorable High Court says bank is entitled to recover the commercial rate of interest. That is in para number 4, clearly mentioned. But my lord, that para I will read, my lord. Exactly they said that bank is entitled to commercial rate of interest.
Provided you do this exercise. How do you do this exercise? You give an opportunity to him, you tell him that this is what it is. You do some exercise, you do ascertain the facts, then you do it. Just like that, you receive a reply on 7/2/2026, 12/2/2026, just saying that in the light of the order of the High Court, you have to pay because it is not set aside. Please come. The presented petition is filed.
My lord, this,
Huh?
my lord, this 13.2 notice, my lord, this entire thing, whatever produced, this may be brought on record, my lord, because now with the same issue that, and
When was the 13/2 notice issue?
that is on 26th February.
How can you do? Without giving him an opportunity, without even understanding what is the commercial rate, what is the exercise you have done? How come you can
No,
say
before
that this
that
is
only,
outstanding?
my lord, lordship, see that before that only we have informed. Bank has informed that because of this we are going to charge commercial rate of
But the
interest.
court has asked you to do it again, that you are supposed to do. Please come. The writ petition is filed, seeking the following prayer. The petitioner has availed the loan from the second respondent bank.
My lord, for this, that when the bank asked you to submit the documents, he has not submitted it. If that is done, means that the wrong bank would have taken.
You should have stated so in your impugned order. I think in the typewriter, the cartridge is not
Oh,
available.
my lord, even that my order, instead of from, that is.
When you're passing an order, it should be a speaking order considering all the, what has been stated by the court.
Serial
He has
number
availed the loan
26.
from the respondent. He availed the home loan of an amount of rupees 4,35,000 crores. As per the sanction memo dated 29/7/2007. Out of that, a sum of rupees 2.10 crores was towards purchase of the site, and a sum of rupees 2.25 crores was sanctioned towards the construction of residential building. Out of the total sanctioned amount of rupees 4.35 crores, the respondent number 2 had disbursed a sum of rupees 1.9 crores towards purchase of the site and rupees 75.91 lakhs towards construction of ground plus 3 floors. The petitioner has purchased the property as per the registered sale deed dated 11/8/2017. The petitioner's name is mutated in the records. Also, petitioner has applied for the sanction of the building. Thereafter, after completing the construction, petitioner has let out the premises and paying the property tax. Petitioner is having 2 loans with the respondent bank and has been paying the EMIs regularly without any default from the date of sanction. On 22/9/2025, they have received the notice from the bank stating that the construction is found to be in violation of the sanction terms and conditions by the internal audit. And in view of the same, backdated differential rate of interest after charging commercial rate of interest from the financial year 2019-20. And the bank has retrospectively revised the rate of interest from housing loan to commercial rate of interest and asked the petitioner to pay an amount of rupees 86,87,297 as current outstanding in the home loan account as on 22/9/2025, out of which rupees 57,34,731 in one loan account and rupees 29,52,566 in the other loan account, and further reschedule both the EMIs. The respondent bank unilaterally rescheduled the loan and called upon the petitioner to pay outstanding interest amount with retrospective date from 22/9/2025. After receiving the notice dated 22/9/2025, the petitioner has issued the reply that the site in question is in a residential zone and the petitioner has put up construction of dwelling house. Petitioner, being agreed with the order dated 22/9/2025, has filed a writ petition WP number 32636 of 2025. And initially, an interim order was granted on 22/9/2025. Later, the said writ petition came to be disposed of on 27/1/2026, whereby the court has directed the bank, after ascertaining all the material data, such as all material data, they can charge the commercial rate of interest. Subsequent to the same on 10/2/2026, the petitioner has sent a representation, along with the copy of the order, he has given a representation on 7/2/2026. The respondents have passed the order in view, have issued the proceedings dated 12/2/2026, whereby it is stated that they are in receipt of the order from the High Court dated 27/1/2026. And on perusal of the order, it has been observed that the High Court has clearly denied the prayer for quashing of the communication dated 22/9/2025, wherein the bank has communicated regarding application of commercial interest from 22/7/2019. And it is informed that the said letter dated 22/9/2025, bank has debited the differential amount between the applicable home loan interest and commercial rate of interest, amounting to a total of rupees 87,47,566. In terms of the order passed by the High Court, they requested the petitioner to pay the amount. And it is further stated that the court has not quashed the communication issued by them are not ordered to refund the amount collected pursuant to the notice dated 22/9/2025. Land Council appearing for the petitioner submits that the letter dated 12/2/2026 is in clear violation of the orders passed by the court. The respondents have not done any exercise as ordered by this court, and according to the respondents, the court has not quashed the proceedings. As such, as per the earlier order, the petitioner has to pay the amount and they are entitled for the commercial interest. It is submitted that this is contrary to the order passed by in WP number
32636, page 91.
WP number 32636 of 2025 dated 27 January 2026. It is submitted that the order, the proceedings needs to be set aside. Land Council appearing for the respondent bank submits that the court has not passed any order in favor of the petitioner. In fact, the court has upheld the commercial interest to be charged as per the proceedings stated, as per the earlier proceedings issued by the bank. It is submitted that as the petitioner account is declared as NPA, they have issued the proceedings under section 13(2) of the Surface Act. It is submitted that as per the procedure in vogue, the bank has charged the commercial interest and there are no grounds to interfere in the writ petition. Anything else?
Procedure and documents, my lord. Procedure and documents produced.
Procedure and basing on the documents, they have levied the commercial interest on the loan amount. Next para. Having heard the counsels on either side, peruse the petition on record. Earlier, when the respondents have levied the commercial interest, as per the proceedings dated 22/9/2025, petitioner has filed WP number 32636 of 2025, which came to be disposed of by order dated 27/1/2026. It is appropriate to extract the said order, paragraph 4 and paragraph number 5. A bare perusal of the said order discloses that the court has observed that the respondent bank will be entitled to charge a commercial rate of interest from 22/9/2025, but it has to charge rate of interest at the rate for any period of time from 22/9/2025 only after ascertaining all the material data such as the above. In that case, the petitioner has given the representation on 7/2/2026. The impugned order is passed on 12/2/2026. The impugned order the impugned proceedings does not disclose what is the exercise that is done by the bank pursuant to the order passed pursuant to the order dated 27/1/2026. The documents or other things that the respondent bank is referring to, this court cannot consider the same for the reason when they have issued the impugned proceedings. The impugned proceedings should have a reference to the order passed, should have the reference to the order and the exercise that is done pursuant to the order passed by the court. In the considered opinion of the court, the said exercise is not done by the bank, and if at all they have done, they would have disclosed in the light of the order passed by the court. This is the exercise they have done, and this is the amount they have arrived at, or the earlier amount that is arrived at by them is correct in the light of the same. In the considered opinion of this court, the proceedings rated so and so cannot.
My lord, liberty may be given us to do the exercise, my lord.
That's what we'll do.
Yes, my lord.
Cannot be sustained accordingly. The impugned proceedings dated so and so set aside, and the bank in consonance with the order passed by the coordinate bench of this court dated 27 January 2026 shall complete the exercise and shall issue appropriate proceedings. Yes, accordingly disposed of.
Bill number 37 adjourned. 38. P.N. Jayadeva for petitioner.
I'm from the respondent bank.
Yes. What is this?
Madam, this is a writ petition preferred by the auction purchaser
Hmm.
after completion of all the proceedings under SURFACE Act by the bank.
What he
Way
wants
back in the
now?
year 2012 itself. After 4 years, he has preferred this writ petition, complaining that the borrower himself is in possession of the property and hence he wants the sale proceeds back.
It is concluded in the year 2012.
2012, madam. On 16 to 2012, it was
2016.
concluded.
No representation on behalf of the petitioner. This is matter for dismissal on 15th. This next.
Bill number 39. 39.
My Lord's kind permission
Yes.
for the petitioner.
Yes.
Lords, two writ petitions, my lords. The first of the one is in writ petition number 5068 and 69 of 2020, of 2019. I would only draw my lord's kind attention.
No, before that.
Yes, please.
39.
Please.
We'll go to the prayer.
Please, my lords. In 39, my lords.
Yes.
Please. That's writ petition number 43845, please.
Writ or order, direction to quash the order dated passed by respondent number 1. Who is respondent number 1?
Is the Karnataka Information Commission.
What is the order?
My lords may kindly see, the order directs me, the Waqf, I'm a Waqf institution, to my lords, give out information. To give out certain information as sought by the private complainant on 3/10/2018. There
What
was,
is the information sought for?
my lords, I will.
Public information. Public information.
What is the
The
information?
assets acquired by the institution. The assets acquired by the institution.
My lords will find that,
The information that is sought is which are the properties that are held by the petitioner within the.
my lords will find the complaint in annexure K, page number 73. My lords will find the complaint. Certified copy of properties.
Any law on this with regard to?
My lords,
this
I'm not a public institution. My lords, let them show one order which shows that a Waqf institution is a public authority for them to make access.
No. Are you under the control of the?
I am not. My lords, I am a society. I am a society registered under section 13 of the Societies Registration Act. That is why I would draw my lords' kind attention to the first of the writ petition in 5068 of 69. I have, my lords, impugned the earlier order passed by the commission, and this honorable court has stayed that order. Notwithstanding the stay order, the same complaint has been reopened and this impugned order has been passed.
Let me understand.
Please, my lords.
Your, what is who is a?
My lords,
Jama,
I'm a
Masjid
society.
and Muslim
Yes, I'm a
Charitable
society registered under Societies
under
Registration
the-
Act. I, my lords, filed my audited account before the society, the registrar of societies, and I also, my lords, in compliance with section 46 of the Waqf Act, also filed my audited accounts before the Waqf board. My lords, I'm not under the aegis of the government. I am not a public institution in any sense of the word.
May I take this honorable court directly to the point? Please see section 2H of the Right to Information Act. Right to Information Act, section 2H says, who is a public authority? Whoever receives government grant is a public authority. And it is.
But I'll tell you, there is an order where I was, no.
My lords, let me answer that. I'll clarify that in one moment.
I'll hear you.
Please, I will clarify that in one moment. We don't need to go round and round.
Petitioner in the petition admits that he has received a government grant. It's
So that's what,
budgetary allocation.
that itself is not sufficient. No, there is a judgment saying that all the temples which are working under the administration of the government, which are public charitable institutions, they are not amenable to Right to Information Act. And did you have an occasion to see the judgment?
I'll go through.
There is a judgment. So every authority will not come under the Right to Information Act.
I'll go through.
But there are two judgments which would be relevant in this case. One is Talapalam Education Society is one of the Apex Court. And also, my lord, there is one judgment of DAV Educational Trust. wherein all the section 2H has been considered by the appellate court in detail. And it has said which are the institutions, what kind of institution will fall within the definition of a public authority and right to information act. And what kind of financing. Not the word, though it is used in section.
No, now what I am saying here, now he is, as far as it's a society registered under the Registration Act. I am referring to a temple which is registered as a public charitable institution, a public charitable and endowment institution. That institution, a batch of institutions have filed the writ petition in the High Court in Andhra Pradesh. It held that that they are not amenable to the writ jurisdiction. I was appearing for the institutions that time.
Subsequent.
So please look into that.
My lord, one submission, my lord. I am representing my lord Waqf board, my lord. Under section 32, my lord, all the Waqf institution is generally superintended by the Waqf board, my lord, constituted by the statute.
That is the reason why I said about the temple also.
Notification, my lord, has been issued. Notification, my learned friend petitioner is challenging, my lord, is notification for appointment of public information officer and first appellate authority. So that has been, circular has also issued, my lord, in this regard, appointing the
No, we'll hear
secretary.
this matter. Please go through the judgments and place the judgments.
Then in that case, please fix a date.
Yes.
Preferably on
This
the
is
15th
matter
or 16th.
on,
15th or 16th.
My lord, Honorable Supreme Court, my lord,
already my board is full. We'll have it on 24th.
Supreme Court, my lord, in
My lords, in
the
5068.
I'll hear all what Supreme Court said. I would like to know what Supreme Court said. We'll hear it on that day.
My lords, in 5068, the interim order granted was until the next date of
It
hearing.
is. Wherever interim order is there, extend it in the next date of year.
I'm ever so grateful.
Then number 40 adjourned, 41. Prashant Popper, for petitioner.
May I please, my lord?
One query.
My lords, 41, 41.1 and 2, my lords. Although, my lords, of various vintage pertain to the same matter, my lords. 41, my lords, is a 2020 writ, my lords.
Yes.
Whereas, my lords, the other two are 2025. Lords, in the point 1 and point 2, your lordships had heard the matter at length. I'll just, my lords, place the facts very briefly. I am, my lords, United Breweries Holdings Limited, the erstwhile directors. A loan which was taken by Kingfisher, my lords, went bad. There is a recovery certificate for 6,200 crores that was challenged, etc., all held against the company. Therefore, that is cast in stone, my lords. That 6,200 crores recovery certificate carried an interest of 11.5% with annual rests. What happened, my lords, is that I, as United Breweries Holdings Limited, had stood guarantee, and therefore I was dragged into that recovery certificate, my lords. So I have coextensive liability. Monies were recovered out of various assets and shares, my lords, that were sold. Over a period of time between 2017, my lords, and 2024, 14,131 crores are recovered, is, my lords, today a solemn statement by the finance minister on the house, plus, my lords, by the finance ministry report. It is in that light, my lords, a writ petition was filed before your lordships, seeking my lords' jurisdiction on the point that if I am liable to pay under the recovery certificate as it is, and interest is amenable under the recovery certificate, and 14,000 crores have been made over to the banks, then the banks have an obligation to inform the recovery officer of the exact principal amount and the interest that is recovered, because according to us, we have discharged that liability in full. The recovery officer, my lords, on 4 occasions asks the bank to file, my lords, affidavits indicating whether this liability continues or not. Those banks do not seem to have done it. It is in that light, my lords, we came up before this honorable court seeking a mandamus, my lords, to the banks and the recovery officer to, my lords, bring the distinction between the recovery of principal and the interest. My lords, in the meanwhile, there was an earlier writ, my lords, which was filed, which is item number 41. That writ, my lords, today, respectfully, subject to what your lordships will hold, may not really hold much water, my lords, because that writ was filed predicated on the fact that if I am to pay certain monies on a recovery certificate and my assets are attached, and if those very assets under the Prevention of Money Laundering Act proceedings are attached, my lords, to be given over to the central government, from the date of the attachment under PMLA, interest should not accrue to me. My lords, if I win on that matter, my liability may come down. But even if I lose on that matter, my lords, my liability then is crystallized at 6,300 crores plus interest. Even on that count, my lords, I had paid was my submission. Your lordships heard me, your lordships of course heard the banks. And the learned counsel, my lords, for the official liquidator had something to say against us, saying we have not complied with their notices, etc., for which he said we may be prosecuted. But it stood at that point, my lords. My only prayer would be, my lords, if your lordships could, I understand, my lords, substantial time has elapsed. If your lordships could put it up on a day, my lords, and put us to time.
No, it's 41.1, and what is this?
My lords,
My lords, 41,
appearing for
41.
respondent number,
I'm
the official liquidator.
So sorry.
So 41.1 and 2 are connected.
My lords, 41.1 and 2, my lords, are on the same issue by two different erstwhile directors. 41, my lords, is by
Old writ petition.
the older writ petition, my lords. And my request would be, my lords, all of them, if 41.1 and 2, my lords, are decided one way or the other.
We'll have it on 24th.
24th, please, my lords. My lords, would it be possible, if I may pray this, my lords, subject to, of course, my lords' convenience? My lords, 25th is a working Saturday, my lords, if it could be 25th.
No, nobody is ready to work on 25th. That's why I said 24th.
My lords, subject to my lords' convenience,
No.
I would come.
Court is ready. Advocates, nobody says, if they say 25th.
I'll request.
We would request for 23rd if possible.
My lords, I come from Delhi. My only prayer is 25th. If I'm heard, my lords, thereafter they could accommodate.
No, better.
25th, there is
No,
already a
even for the
part
court also, it's convenient on that Saturday. We'll have it on Saturday.
Saturday, we are all right with Saturday.
Yes.
Yeah.
24th, there is other
Yeah,
other
other-
matter.
exactly.
That's why we'll have it on 25th.
25th, much.
25th, 24th,
You said you have a partnered matter. So that's
20,
why.
25th is one partnered matter has been.
It won't take the whole day. We'll have it on 25th, convenient for the court to
Please,
hear.
I'm so very grateful.
25th.
Then number 42,
Petitioners.
42.
Petitioners sought for a bit of mandamus, directing the first respondent to release the title deeds which was given by the petitioners at the time of a loan was sanctioned to the one of the Somnath. After due clearance, my lord, the annexure B is the clearance letter, my lord. No due certificate has been issued.
Let's see the prayer. What do
Please,
you
my
see?
lord. Page number 16, my lord, 16.
Directing the first
14,
respondent
yes,
bank to
ma'am.
release the title deeds of the scheduled property who have sanctioned loan to the prospective buyer on assurance of the respondent bank. What is that?
Here R2, my lords, he has sanctioned loan to P2, now he is transferred to P, he was earlier R3, now he has been transferred to P2. So he has availed loan from us for purchasing a property of P1.
Oh, there are two petitioners.
Now he has two petitions, earlier it was one, now it is two.
You have sanctioned loan to whom?
We are sanctioned loan to P2, my lord. So the title deeds are with R1. So we have dispersed the outstanding, entire outstanding amount to R1, but they are not parted with the title deeds. Now they have closed the loan.
Which one is India Bank?
Indian Bank, we are LIC Housing Finance.
LSC Housing Finance.
Yeah. We have sanctioned loan to the P2 based upon the documents with R1. So R1 is supposed to give the documents to us, but they are not given now. Till now they are not given.
Why they are not giving?
They are telling that they have been extending this property to some other loan account. The P1 is a guarantor and borrower in some other loan account. They are extending to that loan account now.
Why for bank there are no rules?
It is there, my lord. They have given NOC also, my lord. Page number 18, they have given NOC also. After
Appears for
closure
the
of this
Indian
loan.
Bank.
Nobody has appeared.
Yes, who appears for the Indian Bank?
Earlier it was HR Katti, he has given NOC.
HR Katti is appearing.
No, he has given NOC. He has given NOC, but nobody is there now.
From the beginning, my lord, they have not appeared before this.
Who appears for the Indian Bank? Who are the councils? You appear?
No.
Who appears? Who are the councils appearing for Indian Bank? Look at it, a list is there.
Indian Bank, Muttanna, TP Muttanna.
Where is Muttanna? Mr. TP Muttanna is directed to take notice on behalf of the respondent bank. Serve the papers on him.
Please, please.
On behalf of the first respondent bank, lend counsel to the petition, serve the copy of the writ petition on the council. Let this matter after vacation.
Then number 43. 43. Santosh S. Bogi.
For the petitioner, my lord, matter got settled.
Settled. Then give a memo. Give a memo. Where is Mr. Vignesh Shetty? Yes, Mr. Muttanna, in that matter, please take notice after vacation. Yes,
43, Santosh Gogi.
For petitioner.
yes, 43.
For petitioner, my lord.
Says it is closed. Land counsel for the petition submits that the loan account is closed and nothing suffices for consideration. Accordingly, the writ petition is dismissed as infructuous. Yes, 44.
Cell number 44. 44, Subramanya Bhattam.
Correspondence.
Lords,
Agarwal.
Lords, this matter pertains to allotting of retail outlet in Indian oil, my lords. Now, my lords, the primary requirement is the land, my lords, which is now I don't have. So it becomes infructuous, my lords. So maybe recorded as infructuous.
The petition is filed seeking the following prayer. Land counsel petition submits that the primary requirement for allotment of the retail outlet is the petition should be in possession of the land for establishment of the same. The petitioner at present, petitioner is not having the land as such. He is not pressing the writ petition. Accordingly, the writ petition is dismissed as not pressed.
Lords,
Yes.
Cell number 45.
Week's time. 1 week's time.
Why?
Some information by my clients.
Pragati Cooperative Bank.
Bank, but whether he is in position or not, another your last.
No, the.
Monday, your last Monday.
Huh?
Monday.
List on 15th. No further time. Yes.
Cell number 46, 47, adjourned. Cell number 48. 48, Parshuram AL. Parshuram AL.
No representation for dismissal on 16th.
Cell number 49. Sri Rajshekar.
Appearing for the petitioner. Last occasion, your lordship directed them to file an affidavit. It was here, my lords. Muttanna.
Directed whom to file the affidavit?
The bank, my lords. Because.
Where is Mr. Muttanna? He was here just now.
He's here. And he's not served the copy also, my lords.
TP Muttanna. 49.
Give the order sheet. There's this
My lord,
matter,
that
by
we
the time the council appear, the place shall place before the court, how they have arrived at an amount of rupees 18 lakhs or whatever is outstanding amount. And a
My
day
lord,
before
this
the
is
said
my
date,
ob-
statement shall be given to the council for the petitioner.
My objection and statement of account is there, my lord. That what? Objection and statement of account in this matter, that Prakash construction. I'll give. I was sent to, but the another. copy
No,
they
man.
want. Take.
That's
No,
why
here
he
my
said-
lord, outstanding amount, that 30 lakhs. it
Let
comes.
them, that's
Yes,
why I
ma'am.
said that before a day before, you should have given as per the order passed for this court. Then counsel for the bank has placed before the court the objections along with the statement of account. The same is served on the counsel for the petitioner. Place this matter on 24th. Yes,
Cell number 50.
look, interim order is there.
No entry matter.
Yes.
Just a small submission with respect to
Next.
serial number 48. I appeared for the petition. Apologies for not being here during the first round of killing. Serial number 48, your lordships. Apologies for not being here during the first round of calling, your lordships. There's an interim order and I'm unsure as to what has happened.
Then argue. I'll pass over.
Kindly
48
pass
over.
it, lordships. Kindly pass it.
Yes, 49.
Great.
48 percent. 49
And it's 50.
50, I appear for respondent number 2, my lord, Panchayat.
In this case, the fishing rights, the respondents, the denial of fishing rights after accept my amount,
Let's
4
see.
lakhs 70,000.
Let's see, come to the prayer. What is that you're seeking? Issue direction to the respondent to consider annexure F dated 1910 by way of mandamus. What is annexure F? Why it can't be stated in the prayer?
Number 20, it is in Kannada, my
What is
lord.
this representation?
Representation, my lord.
What is the
He's
representation?
seeking refund of the amount, my lord.
Representation, annexure F.
He's seeking refund of the amount. He was a successful bidder for fishing, my lord.
But my lord, denial, no order has been issued from the date of accepting the money. There are no use.
Yes. You appear for whom?
Respondent, Panchayat, my
Huh?
lord. Panchayat. We have issued tender, my lord.
So what are your instructions?
Lord, my instructions are that, my lord, in the guise of the interim order, my lord, he is seeking refund. Interim order was granted by this honorable court. He is doing fishing in the night time, night hours.
Then you take action.
Lord, we have instructed. They have called me and I have
Then let
instructed them
take-
to
So what we do
proceed
is,
in accordance with law.
We'll pass an order to consider his representation in accordance with.
Please,
law.
my lord, please.
And you do whatever you want to do.
Please, my lord.
The writ petition is filed, signing the following prayer. It's a case of the petitioner that the petition is an agriculturist. The second respondent has invited tenders under auction notification for issuing, for fishing. Petitioner has participated in the auction and deposited an amount of rupees 4,77,500. As per the tender notification, within 7 days from the date of finalizing the tender, the fishing rights will be, the proceedings will be issued for grant of fishing rights. It is this case that, but till today, it is not issued. In this regard, he has made a representation to which respondent? Second respondent.
Second respondent.
On
Annexure F.
on 19/10/2022, the same was not considered, which made the petitioner. In this, what is the stay?
Lord, his prayer is that, my lord, interim prayer. No measure.
No, for disposing of the representation, what is the stay?
Lord, he says, all the further proceedings pursuant to Annexure A, that is a tender procedure. Tender, he has sought stay.
That is granted.
That is granted, my lord.
What did you write? So and so, and the same was not considered, agreed thereby. The petition has come before this court. A coordinate bench of this court on 15/12/2022 has granted an interim order of stay of operation and all further proceedings pursuant to Annexure A. But it would be against him.
Please, my lord.
He is a successful bidder. Proceedings pursuant to Annexure A till the next date of hearing, and that interim order has been extended from time to time. Land counsel for the petitioner submits that having granted the as the petition is the highest bidder, having taken the amount from the petitioner, they have not issued the work order which compelled the petitioner to come before the court. Next, land counsel appearing for the second respondent submits that the petitioner having taken an interim order here and he is doing the fishing in the night. Shall I say? Shall I record it or not record?
Please. I don't get, my lord. Pardon, my lord.
Shall I record it?
With respect to, my lord.
Your submission that he is doing fishing in the night.
Please, my lord. That may be a record, my lord.
Doing fishing in the night, at the night time. It is submitted that the petitioner, why have you not issued the work order? What is the reason for it?
To that extent, I don't have instructions, my lord.
It is.
We'll consider his representation.
Having obtained a stay and without paying any amount for the further years, he is enjoying the fishing rights. Next part, having heard the counsels on either side, there is a material on record. Petitioner seeking a writ of mandamus, directing the respondents to consider his request dated so and so. Without going into the merits of the matter, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the respondents to consider, the second respondent to consider the representation of the petitioner dated so and so in accordance with law. Number 2, if the petitioner has done anything in violation of the rules, it is for the respondents to take action in accordance with law. Accordingly disposed of.
Number 51.
Direction minute, complaints minute, this order will be considered within 2 months or 3 months.
Shall pass appropriate orders within 4 weeks from the date of receipt of the copy of the order.
Please.
Yes, next.
51.
For the petitioner, kindly pass over.
Done.
I appear for the respondents in this matter.
Seek a Passover.
Passover has become an order of the day. Yes. Passover.
52. Respondent Shantan Gowder for petitioner.
That's appearing for the
MS
petitioner.
Devaraju.
What is this memo for disposal?
Lord, view of the fact that they have
This case-
admitted the liability, they have admitted the liability of payment of certain amount to the petitioner on account of digging of borewells. And thereafter, my lords, we approach this honorable court to release, to consider representation for release of funds. They have now given a representation stating that there is no work order issued to you, so hence we are not liable to make the payment. But there are several communications where they have admitted that due to scarcity of funds, we are not able to pay the petitioner for digging of borewells. Around 1 crore 41 lakhs is the due amount, my lords, on account of drought situation in Ramnagara district. 84 borewells were dug according to them, and 1 crore 41 lakhs was the due amount.
Memo for disposal. Is it a early hearing?
In this case, my lordship.
Huh?
In this case, my lordship, earlier, respond number 3 is consent.
Filed by you?
Yes.
This memo for disposal is
No,
filed
we
by
have,
you.
we
I am
have,
not
we have
filed.
filed, my lords.
Alla,
We have filed.
Memo for disposal.
My submission is consent, my lordship.
Is it a memo? It's a early hearing?
Early hearing.
Are you for a early hearing?
Because, my lords, since 2016, they have been evading payment.
One submission, my lordship. Respondent number 3, earlier, Somayaji is appear, my lordship. He is no more. Presently, I have appeared. I
What
take
is your
instruction
name?
from the
Your name
authority
is there?
also.
Yes, my lords, on the last date of hearing, your
MS
lords.
Devaraju.
I am the MS Devaraj, my lordship. Petition copy has not served with me, and also, we are
No,
not
no
getting any
copy.
instructions.
We have
Served,
taken
my
on
lords,
some other day.
endorsement is also issued.
It is the petition is also the copy of the writ petition on the council appearing for R3. And R3 shall get instructions in this regard. It shall get instructions. List this matter on 28th.
Achha,
Is 53?
28 of 6, my lordship. 28/6. 28 ಯಾಕಂದ್ರೆ instructions ಬೇಕಾಗುತ್ತೆ
Lords, since
June after
2000
vacation
since
only.
2016, my lords,
Allala.
and 2023.
They're asking for an early hearing and you say after
ಅಲ್ಲಲ್ಲ,
vacation.
ಅಲ್ಲ ನನಗೆ instructions
If you don't get instructions, I'll pass orders. What are they doing from 2023? Yes,
clear
yes.
on some other advocates appear, my lordship.
Whoever it is. Institution is the same.
The respondent bank, your lordship.
Kumar.
This is pertaining to coffee plantation, your lordship. Last time they had sought time. They are
Yes,
admitting
where is the
that
council?
today.
No representation on behalf of the petitioner and this is matter for dismissal on 16th of April.
Cell number 54. Cell number 54.
Kindly pass.
Narayan Bhatt.
Pass over.
Cell number 55.
My lords, and for the petitioner.
All passovers call at the end of the list. For asking for a passover, they should wait till evening.
The other side also will wait. That's it.
What to do? Yes.
My lord,
55.
in this petition, the petitioner has filed the undertaking affidavit to clear the debt within 6 months. Recount the consent disbursement.
There are 3 petitions pending before this honorable court. In the writ petition number
Dispose of that late, my lord.
2 writ petitions will not survive for
Go
consideration.
for by one after the other.
Please, madam.
First,
The-
let's see 55, 4834 of 2026. What is the prayer he is seeking?
My lord, sought for prayer. Page number, my lord, it is only writ of.
Passing annexure E dated.
Read, madam.
What is this annexure E?
My lord, this is a notice, can you see, my lord, page number? Directing the petitioner to remove all the mobile properties kept in the house of the petitioner by virtue of the order passed by the
I'm
criminal
looking
minister.
at WP 4834. You're reading something else.
Correctly. Lord, annexure E, my lord, typed, page number 23 is a typed version, wherein page number 22 is my letter, that is my lord, sale.
Typed copy, yes.
My lord, section 14, my lord, prayer B is my lord, section 14 order. Prayer 1 is pursuant to section 14, we requested him, but however, we have taken a position of property, the position with us.
Prayer 1 is 14 order.
Prayer 1 is my letter stating that you vacate
For
yourself.
the, yes.
Prayer B, my lord, section 14 order.
So what is to be done in this?
In this, nothing survived because we already taken a position of the property and position with us.
Sale is also conducted.
Sale, actually. Sale, my lord, not.
You've
Sale is
taken physical
not
possession
take
of the
place,
property.
Sale
physical
not take
position with
place.
us.
Go before the DRT. What is the next
What happened,
petition?
Lord? As per this court direction, I filed the affidavit, undertaking affidavit. That's why the affidavit, my lord, as per the
So
record,
whatever it is, what
cannot
affidavit
recount
that you
very-
are ready to pay the money?
please, 6 months, court, I filed the affidavit, my lord.
What is the amount?
23 lakhs, my lord, it is.
28.
Out of that, already cleared 20 lakhs,
So
my
how
lord.
much time you want?
6 months, my lord, 6 months.
This honorable
Because
court given an
petitioner
opportunity.
is in
No,
great,
no.
very tenacious position.
This honorable court given a multiple opportunity, but connected matters also, this honorable court granted stay. Sale assailed, stay granted, sale
Left
not
for the court,
confirmed,
my lord.
and sale not took place. And one more, my lord, consider the
6 months
representation.
is, 6 months we can't grant.
4 months, my lord, just 4 months. Get minutes. Get.
File an affidavit.
Only filed long back. 9th March, filed the affidavit.
You're saying it is 6 months. I'm saying 4 months.
This
You
court
have to file an
modified that matter,
affidavit.
regarding, my lord.
Huh?
Modified, my lord. Without
Huh?
6 months, 4 months, my lord.
No,
Modified.
no. It should be by, you file an affidavit like that.
I have it on tomorrow, minutes, my lord. Or Monday.
Two matters, my lord, can be disposed of. Nothing, it will not survive for consideration.
No, all the three we can do it at a time. He says tomorrow he's ready.
Wait, my lord, ready all.
Not tomorrow, list this matter on 16th of April. By the time the counsel for the petitioner has submitted before the court,
Wait,
by the time the petitioner, it is submitted with the counsel of the petitioner that petition is ready to pay the amount within 4 months. And in that regard, he will file an affidavit. The same shall be placed on record by 15th, list this matter on 16th.
Great, my lord. My lord, the interim order is continued, my lord. Please, great.
Further hearing, cell number 56.
Yes.
Mahesh Chaudhary.
That's this matter, that's where I've challenged the initiation of the proceedings under
Here it's
section.
1:30, we'll take it up after lunch. Yes.
Grateful.
My lord, serial number 43. My lord.
No adjournments now.
Adjournment, no.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ನೆನ್ನೆ ಅನ್ಸುತ್ತದು. ಒಂದ್ ನಿಮಿಷ. ನೆನ್ನೆನೆ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಬಂದಿರೋದು. ಯಾವಾಗ?
56 ತನ ಬಂತು.
ಕಾರ್ತಿಕ್ ಎಸ್ ಅದ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಹೇಳ್ತಿಲ್ಲ ಅದು. ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಕಾರ್ತಿಕ್ ಎಸ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಲೇಟ್ ಆಗಿ ಕುತ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ. ಕೇಸ್ ಕಟ್ಟಾಗ ನೀವು ಇರ್ಲಿಲ್ವೇನೋ ಗೊತ್ತಿಲ್ವಲ್ಲ ಸರ್. ಒಂದ್ ನಿಮಿಷ, ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಅಲ್ಲ? Is this matter on 9/4? No representation. Is this on 7/4?
Second matter.
ಒಂದ್ ನಿಮಿಷ, 7/4 ಅಲ್ಲಿ ಅದು ಡಿಸ್ಮಿಸಲ್ ಏನಿಲ್ಲ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಆಗಿದೆ ಅಷ್ಟೇ. ಡಿಎಸ್ ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ಸೆಕೆಂಡ್ ದೇವರು.
ಎರಡನೇ ಮ್ಯಾಟರ್ ಮೂರನೇ ಮ್ಯಾಟರ್
ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 7/4 ಅಷ್ಟೇ. ಆದ್ರೆ ಅವರು ಬರ್ಕೊಳ್ಳುವಾಗ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಯಾವ ತರ ಡಿಸ್ಮಿಸಲ್ ಅಂದ್ಬಿಡ್ತಾರಲ್ಲ, ಏನೋ ಬೈ ಓವರ್ಸೈಟ್ ಆಗಿದೆ, ಹೋಗ್ಲಿ ಬಿಡಿ ಸರ್. ಇನ್ನೊಂದ್ಸತಿಗೆ ರೆಪ್ರೆಸೆಂಟ್
Milords, I have submitted the written public.
Yes, yes.
Just one attention I seek you, ma'am. Order dated 1st September 2025 in the same matter, and subsequent court proceedings we taken note of. And similarly,
I'll consider everything that has happened after filing the writ petition and your written submissions, and will pass on.
My lord, we have already given the documents. Court directed us to supply the agreement copy, and with an acknowledgement we have supplied
You can also give your written argument. Take that.
the documents.
With my lord's kind permission, at serial number 43, small clarification, where my lord's writ petition has been disposed of as it become infrastructure. Since matter settled, my lords, we were challenging the proclamation, sale proclamation. Only my lord, sale proclamation has to be set aside because settlement has taken place.
The sale not took place, and in
The proclamation
then
notice which was
that
there,
become
that has to be
infrastructure.
go off, my lord. That's only my request, because settlement has taken, we have paid money, they have returned my documents, but the
What is what remains?
proclamation remains, my lords, on that. That, my lords, would come in way, my lords, where we deal with the property, that's all.
Which is the item?
For serial number 43, my lords.
43. Instead of saying infectious, the sale proclamation is set aside in the view of the settlement.
Grateful.
Yes.
Highly good.
Call that Dharwad matter.
Matter pertains to Dharwad.
I appear,
Yes.
Millards. I beg to Millards apologize. Yesterday, Millards, I didn't have file. So that reason, Millards, I could not able to. But now, Millards, I have file. That's may I make audible? Millards?
That's the only clarification I want, nothing else.
Please, Millards. That's first submission is Millards. The calculation should be Millards from the date of, that's the Lordship may kindly find 18/9/2025. That is the Millards last date and time of receipt of tender. Calculation start from that date, Millards, as per the circular, Millards.
So within 48 hours, that is 29/2025.
Yes. That 48 days, Millards, complete on Millards 28th September. In
One
the
minute.
Please.
That's either, where is that yesterday? They pointed out.
I'm
that,
Millards, referring Millards 110045 Millards repetition.
11004. The last item in the list. Page number?
Millards, written submissions, Millards, I have given. And the notification, Millards, will find.
Circular.
Circular, Millards, page 90.
It's 95.
95.
Yes. So opening of the technical bid is on 29.
Please.
Then
89 is the late date, Millards. 48 hours, Millards, will come to Millards 29/2025. It is in time.
So it is done. According to you, it is done.
Please.
Then the
Next,
technical
Next, technical bid, Millards. That's a technical bid, Millards. It should be on 30th day, Millards.
On or before 30th day.
Please. That is, Millards,
That is-
if you calculate from 29/2025, it will be, Millards, 21/10/2025.
No. You can't calculate it. You have to calculate it from 18th.
No, 18th, Millards, will end. No, 18th will be, Millards, only for the technical bid. Technical bid, Millards, 48 hours, it should be, Millards, open. That is, Millards, as per the circular.
That's the whole problem. What you are doing is you are calculating the dates from the earlier event. You have to calculate from the date. Now, if you say for the opening of the technical bid, 48 hours has to be calculated from 18/9. For everything, 30 days, 39 days, everything from that day only you have to calculate.
No, in the notification, Millards, as I have produced, Millards, they have not produced the entire, Millards, that copies. In the notification, in the last portion of the Millards notification, details of, Millards, the bid period has been given.
Yes, page number.
That page, in my written submissions, Millards, impleading, Millards, written submission, page 15, Millards, kindly find. Page 15. Wherein, Millards, first, Millards, that third column, Millards, bid valid period is 90 days. That's it. Got it, Millards?
Where are the written submissions?
It is filed on 30th January, 13th January.
There is a written submission. Yesterday I've seen it.
110045 minutes.
Last, no, this what is that? Is in, that's in the last one. Yes.
That's page 15. That's there is a Miller's dates given. First Miller's
number?
bit valid, page 15 Miller's 15. This document Miller's is not produced by Miller's any of the petitioners. It's a part of notification. Miller's bid valid period is 90 days. Next Miller's last date and time for tender. That is Miller's 29/2025. And next Miller's date and last date and time for receipt of tender 18/9/2025. So as for circular Miller, this date is important Miller. 18/9/2025.
Yes.
From this Miller, from 18/9/2025 Miller.
From this you have to calculate all the timelines.
Please, 48 hours Millers. 48 hours Millers come to the Millers on end Millers on 20th/9/2025.
Then technical bid from 18/9 30 days.
That is what I'm saying, Millers. When Millers 48 hours completed on 29/2025, from that Millers technical bid, the 21/10/2025 Millers will be calculated. That is for the Millers period of 38 days. 38 days. From 29/2025, 38th day will be Millers on 21/10/2025. As per the Millers government circular Millers, I'm saying. As per the government circular. Next Millers opening of financial bid, 35th day Millers.
When is that?
It will become on Millers 26/11/2025.
How can it be according to you, yes, Mr. Mallikarjun?
Yes, Milord, my learned friend may not be right. 35th day Millets would be from the first day itself. It can't be Millets 35 days later.
That's
His
what
calculation is taken.
he's calculating everything from a subsequent date.
No, it can't be because the entire tender period is for 90 days.
That's what.
Then it goes beyond 90 days, Millets. No, there is no purpose in interpreting this through Millets circular at all.
If for a moment, Millers, if I admit whatever Lordship is saying,
that is what is Millers.
While calculating from the date of Millers that 18, 90 days will not be Millers.
Entire period is 90 days. If you keep on calculating from earlier event, it will go to 200 days.
No. That is the Miller circular says. That is the circular says.
So please to give the dates. Let us see how much time it is from the date from the beginning to the end. Yes, opening financial bid is according to you. What is the date?
The financial bid Millers, it is 26/11/2025. It's supposed to Millers open.
The next date, please give the next date.
Next date Millers, it is because of Millers interior order Millers, it has been Millers stopped.
Just give the dates.
Please Miller, please. That is Millers. Next date is
in your written submissions you have stated. Please look at it.
Please. 18/12/2025 Millers.
What is this date for?
This is the date Millers wherein Millers interior orders were passed. But Millers, it's supposed to Millers complete 26/12/2025. Millers may kindly find Millers my submission, written submissions. Total period Millers, total period as on the date of Millers in order, 75 days has lapsed. Third para Millers in written, my written submissions are made clear.
I am on this point. Opening of the financial bid is supposed to be on 26/10/2025, but not like 26/11/2025 as you are submitting.
26/11 Millers, it is not.
No, but Millard, this in fact I had cited the order of the coordinate bench. If I can take your lordship, this is interpreted. This is considered there. And the honorable court has already
No, no,
taken a view.
while dismissing the writ petition, I have taken these dates and I thought it's well within limitation. Then again, while I was correcting the order, again I have looked at this dates. That's why it is posted for being spoken to.
This is how it is considered. The way your lordships are putting it, let's across.
That is not correct. What calculation he has given is not correct.
Yes, in fact, this is the same view taken by the coordinate bench, which I had cited. Your lordships may kindly have the look at that order in WP 9975/2025, passed by the coordinate bench. It is part
of this court has passed an order discussing the writ petitions. The whole grievance of the petitioner is the bids were not, the auction process was not concluded as per the circular issued by the government. The land counsel for the respondent has placed before the court the timeline stating that 29/2025 is the opening of the technical bid. It is completed. And the opening of the 29/2025 is opening of
technical bid.
Opening of the technical bid. And from 30 days from there on, the financial bid has to be opened. The timeline that is mentioned by the respondent is 26/11/2025. That is, he calculated the date from 30 days from the date of technical bid. And while passing the order, the court has not looked at this discrepancy by oversight. While correcting the order, this has come to the notice of the court, and the same is posted for being spoken to before the court. Then counsel appearing for the respondent submits that the 30 days time is from 21/10/2025, and that will be on 35 days time would be from 21/10/2025, and it would be on 26/11/2025. This court is not able to appreciate the said submission, as the 35 days would complete on 26/10/2025. As on 26/10/2025, there was no order. There was no interim order by the court. And is on the face of it, the respondents could not complete the tender process within the time, in the light of the judgment relied on by the learned counsel for the petitioner, which is passed by coordinate bench of this court. In Jagdish's case, referred supra, the petitions are allowed, and it is left open to the respondents to initiate the proceeding, to issue the tender process afresh.
Obliged, my lords.
The order dated so and so is recalled. Yes. The cost list has also gone in now. Continue the list.
Serial number 56, list number 1, serial number 56.
Respondent number 3 in this case.
Lord, I'm appealing for respondent number 1 and 2 in this matter.
That's
With the first petition 18351.
yes, my lords. All are on the same footing, my lords. That's the premise in which the petition has been filed. And
First come to the prayer.
Yes, my lords. The lords would find that at page number 24, ink page number. Prayer A, my lords.
So now, according to you, initiating the proceedings before the DRT is bad.
Yes,
but you have not you have not sought any relief before the DRT, saying that such proceedings are not maintainable.
That's, I have not, my lords.
Yes.
I have not. To begin with, I have not started. I have not even appeared before the DRT, my lords, on the intimation of.
What has happened to this OA?
Lord, it is pending because here there is a stay. It is pending.
Oh, question all that
No,
before the DRT.
may I just take 3 paragraphs of the OA and my lords, 2 sections of the.
I just want you to tell the court. No, they filed a OA. According to you, OA is not maintainable.
Yes.
If you raise such a ground, the DRT can't understand or consider it, or it is beyond the powers of the.
Lords, there is
party
no
to-
such provision under the 1993 Act where I could go ahead. They have gone with the premises, my lords, even in their petition, that I have.
They file a OA.
They
You
filed
will
an
file
OA.
your written statement, isn't it? The written statement, your only one ground would be that these proceedings are not maintainable before the court. That would be decided as a preliminary issue.
Lords, may I persuade my lords to 3 paragraphs, and after that, my lords, I will, I will leave it. Yes. Lords, admittedly, my lords, the entire transaction, my lords, before this, my lords, I take my lords to page number 33, paragraph number 7, 8, and 9. These are the only 3 paragraphs which I would want my lords to look at it. Lords, the issue, my lords, starts from the fact that I am a home buyer.
Lord, before he makes submission, I want, because some pages are missing in this writ petitions. Which page he is referring, I am not able to understand.
Page 33 of my.
I don't have
Paragraph
that.
numbers.
I don't have page 33.
No, paragraph number, what is this document? That
This is
your
a OA document.
Application that's filed by you.
Yes.
In that paragraph number 6 is at page 33. That's not there?
Page 33 is not.
No, not page 33, your application before the DRT.
Oh, it's
OA
jumbled up, my lord. It is there.
Yes. Paragraph number?
Paragraph number 7, 8, and 9.
Read it.
Lords, can I just take the relationship between the parties, my lords? That would, my lords, I am a home buyer who approach a developer, and developer, my lord, says that a particular flat would be ready or an apartment would be ready. And my lords, that's respondent number 2 here. Now, my lords, I enter into a tripartite agreement with the bank, myself, and the developer, with an issue that, my lords, that the entire pre-EMI, which of course the concept which is floated by the bank and developers, my lords, will be taken care by the developer until they hand over the possession to me. Now, my lords, that's the first fact. Second fact, they continue to pay the pre-EMI to the bank till a certain point of time. Now, it's after that they don't continue with the project. They don't start the project. I mean, they some disturbance within their own company, so they don't continue the development. Immediately, which, my lords, I approach the RERA authority seeking for an exit. My lords, I file a section 18 petition there. It gets allowed. I get an exit, and my lords, my agreement of sale, my lords, by an order of RERA, my lords, stands cancelled with them, with the developer.
The bank do not proceed against the developer?
Yes, my lords, that is the exact point, my lords. Now, with this background, my lords, may I request my lords to, and my lords, after my third fact, which I wanted to.
We'll have it in the batch which is coming up on Saturday. There's a batch coming.
I
of
know
this
that batch
tripartite
with regard to
agreement.
my
We'll have
lords
it
had
on that
mentioned.
day. This is matters on, along with the batch, Anita, give that.
That may not
That
be
batch,
connected
my
to,
lord,
that's a
one sub-
different issue.
One,
No, it can also be decided along
no,
with.
one submission, my lord.
No, I'll
That
leave it
batch
to
is pertaining to tripartite agreements. Here in this, there is no tripartite agreement.
Think it's a tripartite
No, no, my lord, there is no
I'll
tripartite.
I'll point out to the fact how the entire liability.
Is there a tripartite
Yes,
agreement?
there is a tripartite agreement. My lords may turn to, my lords, one paragraph number 9. They say that because I can't go and recover the money against the developer, I'm filing a case against you. That's the statement they make. Now, my lords, they do not qualify to calling the money which they have lent to me as debt.
So if whether it is connected with the batch or not, I'll decide it on that day.
Grateful.
This is the matter on 25th. Don't say along with the batch, just on 25th. Yes.
That's, I'm grateful.
25th.
Yeah.
Look at the victim order is there extent.
That's
And
they have it.
actually, may I make a submission? That's,
Yes.
some of the matters, my lords, my impleading application has not been received.
I'll see that.
Please, grateful.
That's, I'm grateful.
Final hearing, MFS, cell number 57 and 58 on 17.
Yes,
I am for the appellant, my lord.
yes.
I have filed this.
Memo
I have
for
filed
return of,
this.
a memo is filed, it's a return of the TPR. the registry shall return the same. And once the amount is withdrawn, the same shall be sent back to the High Court. Yes,
Cell number 58 or 750.
yes. All these matters where it is claimant's appeal on some other day. First
58, I'm appearing for the
preference is
appellant.
to the insurance company's appeals.
58, I'm appearing for the appellant in the first case, my lord.
Hmm.
In second case is the company's appeal, my lord.
17.
Then
17.
both, these two, I already told you tomorrow's list. For these two.
Achha.
Serial number 58, my lord.
It will come tomorrow.
10-4.
Please, please.
59, corporate matter, serial number 59.
58, my lord. 50, serial number 58, might have the next week, my lord. Tomorrow some inconvenience, kindly after next week, my lord.
Next Friday.
Much.
17.
They appear for the respondent, serial number 59, my lord.
59, my lords, appearing for the petitioner. My lords, the senior is not available today, my
What
lords.
is this?
Senior, Mr. KV Dhananjay is not feeling well, my lords. If the matter may be heard next week, my lords.
Give that to the order sheet. Why is it, when it was made? faster?
13/3/2026, your lordships heard the matter in part, my lord.
Then it is listed before some other judge.
Previously, it was before the single, when the division bench,
On 31/7/2025, it is listed before Justice Sri Sudha.
31?
Again on 26/2/2026 also, it is listed before Justice Sri Sudha.
Lord, your lordship may not be the right
But
file,
I'm not
my
able to
lord.
understand why it
This is not the same file, my lord. This case number is 2607.
2604.
Gave MFA.
Different, 2604, my lord. That's a
59.
petition, my lord.
He gave MFA.
MFA. It's a bigger bundle which has two cases, my lord.
Oh, this matter. What happened to your senior?
My lords, he's not feeling well, my lords. He was here today. He wanted to finish the matter, but he
Any
couldn't take-
urgency or we can have it after vacation?
Can go after vacation.
Is this matter after vacation?
Great
Look at it, if any intermod is there extra.
Grateful, my
That is the problem, my lord. Anyway.
grateful.
2022 matter, we are still continuing the file for early hearing.
This is matter on 3rd of June.
Grateful, yes.
Number 60. Cell number 60, Sumana Naganan for petitioner.
Not,
Desha Budhiwal.
bank is before the honorable court. But I have a secured asset in which, my lord, they are storing some cars. The competent authority has been directed by the court in 2022 to remove the cars. My lord, as per Supreme Court's judgment, my lord, when vehicles are seized and it's in their custody within 6 months, my lord, they have to dispose of, otherwise vehicles becomes non-usable.
But the issue, as I understand, is not about, my lords, the cars not being auctioned. The issue now would be, my lords, that the same property where I have parked the cars, they have a first charge. So now, as I understand, the contention that I may be permitted.
This is a property notified.
No, please, my property is not notified
That's
under KPID, my lords. They have the first right, it's undisputed, admitted fact. But the property which is mortgaged to them, I have the cars parked over there, which are a subject matter under KPID, my lords. So I have a claim only over the.
You have a claim against those cars.
Yes. There's an order, my lord, page 86.
How can you, if you have charge your cars, do something about it?
Please, my lord.
But
please,
you
my lord.
can't park it in somebody else's.
I bowed on. The order is, my lord, that I should be recovering the 60 lakhs, and my lords, now that they are able to, my lord, make a submission that they would indeed pay the money to us. I pray for 6 months' time. I will hand over, my lords, the vacant position to them, my lords.
2022 is the order, page 86, my lord, of the petition. Competent court, my lord, has said in 2022 that they should remove the cars and.
Then against that, why did you file a writ petition when an order is there in your favor?
No, that they are not, their government, my lord, this competent authority is not doing anything about it. I'm not.
The special court has passed an order.
Yes, had passed an order already in
Correct. So then
2022.
if there is
I
then
have
how-
given,
How that order will be complied with?
Lord, there is a panchnama done, Lord.
But that's true. The
Yes.
remedy is not writ petition when there is already an order with a competent court.
That competent authority said, my lord, take possession. They have simply, my lord, taken symbolic possession, but they have to, my lord, vacate the property as, my lord.
But I'm asking you against the order passed by the competent court
Yes.
authority. Who is that authority?
The magistrate has passed the order, my lord.
Against an order passed by the magistrate for implementation of that, now you have filed a writ petition.
Lord, I have sought, my lord, mandamus in respect of annexure L, which
What
is
is annexure L?
representation, my lord, 103. I wrote to the Assistant Commissioner Revenue Department, who has, my lord, is the authority, my lord, who has to, my lord, take possession and
Let's
dispose.
see, please come to the cost title. You have written to whom? Assistant Commissioner?
Yes. Second respondent.
Whom you are appearing?
I appeal for the competent authority, my lord, the competent authority under KPID.
He has implemented himself.
Lords, my lords, kindly,
Is ordered.
my lords,
Simply it is ordered.
Yes.
please, my lord, my lordships, my lord, when sitting in Dharwad bench, my lord, the matter was listed before your lordships. My lordships have been pleased to allow my impleading application, so I am now on record, my lords, as a respondent number, my lords.
So when is the order by the competent authority in the year?
2022, my lord, date is 18
Why
to
do you
2000.
want another 6 months' time?
My lords, we are, my lord, there are several cars, my lords, to park. Now, my lords, they will have to use the crane and lift them. I'll produce the photographs, my lord, if that would satisfy my friends. It's not that.
Cars are parked.
Totally, there are 159 cars.
188 cars, my lord.
Mazars
And the difficulty, my lords, that this was a company called Yellow Express. All the colors of the car, my lord, they're in yellow. So nobody would want to buy the cars, my lord. So we are trying our level best to sell them, but nobody is coming forward. So, my lord,
Assuming that you won't be able to sell it within 6 months.
my lords, my lord, we may have to, my lords, do one more or two more efforts and then sell it for scrap, my lords, because the only thing is, my lord, that we were trying to get the maximum possible, because scrap would be, my lords, getting the minimum, bare minimum. So, my lords, I understand. My lords, I have no argument as a right. I'm only requesting that, my lords, if at all my learned friend is generous enough, 6 months, my lord, we'll try our level best. If at all he says, my lord, 3 months only, then, my lords, I will have to. But, my lords, I have no right as such. I will not, my lord, before your lordship, say that I have a right. I am only seeking, my lords, the indulgence of my learned senior friend, subject to my lord's permission, that if 6 months is given, we will be able to do some more better justice is my submission. My lord. Since the merits is not, my lords, the case
They're
here.
all Volkswagen and Nissan cars, good branded cars.
Look,
We're all stuck.
But painted with yellow color.
Correct, but they will not change the
No,
paint.
no, we will grant him 3 months' time.
3 months time, my lord.
You know, this writ petition is pending from a long time. It's almost 5-6 months.
And since, my lords, all our taxi, my lord, registers yellow boards, my
Stand
lord.
them another 3 months from today.
No, ma'am, for 4 months may pray for, my lord.
3 months, my lord, if it is there, if there is necessity, they will, I'm sure they will come back for extension.
Please, my
No
lord.
I think it
extension.
should be 3
No,
months.
we'll give them 4 months. I'll say no extension. At any cost, they have to remove.
Yes.
No, my lords, my difficulty is once my lords pass the order, my lords, I know how difficult it is to get it, my lords, modified. So I will make a submission here, my lords, 4 months, my lord.
That's what 4 months will.
Please, please.
The writ petition is filed in the following.
Lord, one indulgence. Subject to, my lords, the money that is 60,75,000 being paid to me with interest, my lords. That is the.
What is that?
No, no, my lord.
Kindly see the order, my lord. Kindly see, my lords, the
Where
impunity.
is the order?
Lord, my statement of objection.
I made a submission before the division bench where there is an MFA pending with regard to the property, the main property, my lord. I had made a submission before the division bench that if I auction the property, because they have a claim, just to, my lord, get rid of the current situation, I said 60 lakhs I will deposit before the honorable court, which will be available before the court for, my lord, to be dispersed in the manner which the court deems fit. That we will do, my lord, I have no claim so far as the cars are concerned. It is his the cars which he will remove. So far as property auction is concerned, my lord, I have already made a submission in the MFA which is pending before the
That is
division bench.
subject matter of that.
Yes.
No, please, my lord. What has been made absolute by virtue of the impugned order is, my lords, like what was, my lords, in 3.2 was the cars and also the land. The entire notification has now been made absolute. So if this is the case, my lord, then they shall have to challenge this order. Now, my lords, I conceded only because, my lords, I was under maybe a misconception or a wrong, my lords, thing that they will give us the money that is subject matter of the matter. Then, my lords, they could take the land.
No. In respect of this particular property, is there any order that they have to pay? Where is that order?
My lords, at page number 55, my lords, of the impleading application, my lords.
50?
Page number 55, my lords. It will start from page number 40, my lords, but I'll take my lords to page number 54, annexure D, my lord, of my impleading application, my lord, page number
Yes.
54, my lord.
Yes.
My lords, I may be permitted to read, my lord, the operative portion, my lords. The interim application under section so and so is condoned. The petition filed by the petitioner under 5.2 of the Act is hereby allowed with cost. Consequently, by exercising the power conferred under 12.4 of the Act, the interim order of attachment so and so in respect of petition scheduled property is hereby made absolute for recovery of amount of rupees 60,75,000 with interest at the rate of 6% from the date of petition, that is 7/12/24 till the date of recovery. It is further ordered that if the respondents 2 and 3 deposit the above amount within 2 months from the date of this order, the interim order of attachment shall stand cancelled. If not paid as above, the competent authority shall take steps expeditiously for realization of the attached petition scheduled property through a public source. I start there for a while. So, my lord, what has been made absolute, my lords,
Lord, may
is
I
the
make-
entire, so one, please, sir.
May I make this submission?
Petition is Karnataka Bank Limited.
Yes,
Where
ma'am.
is Karnataka Bank before the court?
They are not, my lords.
Lord, we were not.
They are not before the court, my lords.
Then why should they pay you money?
For this reason, my lord, now rightly or wrongly, my lords, the property that now my learned senior friend makes a claim has been attached by the government of Karnataka under 3.2, my lord. That interim attachment of the land in question under section 3.2 has now been made absolute, my lords, by the Honorable Special Court. So the resultant equation today is, my lord, that the property belongs to us. There's a direction that if at all a sum of rupees 60,75,000 is not paid with interest, then I can proceed, my lord, to realize the property. In which case, I would submit, my lord, till this order is set aside in a manner known to law or, my lords, dislodged or revisited, I will have the first right over the property in question also, and also the cars. Only because a submission was made that I am ready and willing to deposit a sum of rupees 60,75,000 with interest. And since the land, we have the first right, my lords, I conceded. But now, my lords, if at all it is the contention between the competent authority and, my lords, the bank, so as to whether KPIDFE will prevail over the provisions of SURFACE or otherwise. Because your lordships, my lords, have been pleased to hear the matter. The Supreme Court has now laid it to rest that the provisions of KPID, my lord, the perimetria provision MPID would not yield and would prevail over the provisions. So anyway, one looks at it. Even if at all, my lord, this order shall have to be challenged before an appellate court.
What I understood and what I remember is only nothing is related to the special court and anything. Only thing is they have the charge over the property and the cars are parked. Now you submit that you don't own the land. You only have you don't have a right on the land. You have a right on the cars.
But now I have the right on the land also, my lord, by virtue of this order.
Lord,
Because
this order is subject matter of 2 MFAs. He has
Where
produced
is
that
that MFA?
annexure E,
before the division bench, please. my
page
lord.
57. Page 57. Lord, I didn't want to be, my lord, penny wise pound foolish, because 8 crores and odd is due to me, which I have not been able to recover. Therefore, in the MFA, my lord, I have now, because competent authority came and appeared in the present proceedings and filed an application for impleadment.
Again, is which order MFA is?
This
filed?
order, my lord, which my learned friend.
May I submit, my lord? Lords,
The criminal miscellaneous order
my
MFA
lord,
is. filed.
against this very order, my lord, I'll submit, my lord.
against
Against
this order.
this order that my lords were now kindly pleased to see. But the original landowners
Section
who
19.
had mortgaged the property.
Section 19 of
So once a help thing, sir.
banning
My lords, the very same order, which I was, my lords, permitted to read before lordships, has been challenged by the original landowners who have mortgaged the land, my lords, to the bank. So the original landowners have challenged the matter before the division bench under section 16. That is the statutory appeal, please, my lord. May I make things more simple, please, my
No,
lord?
no, where is this? Let me see the order in MFA.
But MFA is pending, my lords. MFA is pending before the honorable division bench, my lord.
It was listed yesterday, adjourned, my lord. I had made a statement. I have filed an application to implead myself in the MFA to bring, because of, we came to know about,
We pass an order in this.
my lord,
Now,
my-
who has a charge over the, as of now, they have the charge over the property as per the order passed in the miscellaneous.
therefore, my lord, I made a statement before the division bench that this 60 lakhs and odd, which is determined, I will deposit the money as and when I auction the property.
As of now, your right with regard to this property is not crystallized in view of the order in miscellaneous, which is not even interfered by the court in the MFA. So at this
It is
point
pending.
of time, where are your rights that crystallize that we will ask them to do something?
No. So the two issues, my lord. One is with regard to these cars, which anyway, my lord, they have to deal with it. There is a direction that they should take and deal with it. Supreme Court says, my lord, time frame within which they have to do it. From 2022, those cars are lying there.
As of
One
now,
part.
they are the owner of the property.
Now, my lord, a charge is created by this order in the miscellaneous. Therefore, my lord, I made a statement to which, my lord, my learned friend responded and said that will be
You
feasible.
only made a statement, but that is not recorded by the court.
No, therefore, my lord, that's the reason I was making a submission that that order, this writ petition, once it is disposed of, my lord, I possibly will not be able to deposit the money in this. Therefore, I made a statement in the MFA.
We can't, I'll tag this matter to the MFA.
Lord, my
In
request
fact, it
is,
was tagged, my lords. In fact, it was tagged at the request of the learned.
no, it was not tagged.
Please, I mean, it may be
But
tagged.
my request is this, my lord, kindly allow this petition, record my statement, my lord, that this.
No.
This,
We can't record the statement.
these proceedings have actually got nothing to do, my lord, with the auction to be done by me. My lord, there are two things. One is the cars which are there in the property, which anyway they have to, my lord, not dispose of.
Provided the property, they have a charge of the property, why will they vacate?
No, there's an analogy
No,
also. My
they
lord.
will not vacate. I will take orders, my lord, in the MFA with a condition. I've already made that request before the court.
What I'm saying, I'll tag on this with that writ petition, let it be decided, because orders cannot be passed independently in this. Now, as of now, he has the charge of the property.
I
In the light
have
of
a charge. He admits, my lord, that I have first charge. He also has a charge by virtue of
No, but
this order.
But what happens is legally, when there is when two orders are passed and you have a charge and he has a charge, then the provisions of the
May I
KPID.
clarify,
will
Lord, may I
put the-
clarify, if lost permission. Lord, one is a statutory charge. First or second, my lords, the law will decide. I have an order in my favor. But right or wrong, my lords, I'm not going to prejudge the issue. If somebody is really aggrieved, my lord, then an appeal has to be filed challenging this order.
My lord, my request, my lord, is so far as removal of, I have only come for a mandamus on annexure L. I have given a representation to say that please dispose of, because he's not a.
He's come on record, he has come on record. Now that can't be decided independently.
Lord, my request, my lord, if it is feasible, if it appeals to the court, my lord, kindly record my statement that they will, if they remove the car, and if I, my lord, take any action of under the surfacey, Lord, I will deposit this crystallized amount of 60 lakhs and odd in the pending MFA. It can be, my lord, it is beneficial for both. Otherwise, my lord, no money will be realized.
Passing that order, let the MFA court pass this order also. Learn counsel for the petitioner, for the respondent submits that. The respondent has a charge over the property and also the cars. When a charge is, an order is passed by the special court, that is questioned by the petitioner by filing a MFA, and the same is pending consultation. When counsel of the petitioner submits that there may be an order to the respondent to remove the vehicles, and with regard to the property and the undertaking to pay the amount, an order may be, his statement may be recorded, and the orders will be passed in the MFA, in the considered opinion of this court, when the order in the miscellaneous is stating at the petitioner. At this point of time, this court cannot pass such an order. In that view of the matter, this court deems it appropriate to direct the registry to tag this matter along with MFA number.
5955 of 2025.
Write on a paper and give so that along with MFA number so and so, after obtaining necessary orders from the Honorable Chief Justice.
One submission, my lord. I heard your lordship dictate that petitioners have filed the appeal. My lord, it's not the petitioners, my lord. It is the original owners of the land
Original owners of the land.
who have
has
mortgaged the
filed
property to them. I board on.
The petitioner is a bank, you're right? Original owners have filed up, yes.
Deeply obliged.
Is this cell matter, serial number 61.
Delete from the cap part. Yes.
Here for petitioner, my lord. The respondent 3 has died, my lord. Filing memo.
And from your PM.
No, first of all, what is the writ petition about? You can see that. 2022, when he died,
19/1/26.
let's see what is this writ petition. Section 5 of the Limitation Act. Section 5 of the Limitation Act. IA number 1931 of 2021 for condemnation of delay is dismissed. Consequently, diary number so and so is dismissed.
Smells.
What is the judgment of Justice Pardiwala? Was not somebody, some other judge who was referring to that? Who that in that that Vinayak or Vinayak Swami? Tadani they have referred one month. No, Vinayak Swami, no Vinayak Swami or something said no. That with regard to the limitation, the view which I have taken, the same was taken by the Supreme Court.
Section 5 limitation.
Yeah.
Yes, Mr. Muttanna, which is the judgment with regard to the limitation? Recent judgment. But he has not given the judgment. Not Vignesh Shetty, there is one more judgment.